From contact with you. Just waiting for our confirmation on the live stream.
Sure. We can do how much it's talk.
Good morning. I'd like to call order the Connecticut State Board of Education impartial hearing with the Killingly matter. Start with some introductions. My name is Erin Benham. I'm the Vice Chair of the State Board of Education. To my right.
Good morning. My name is Eric Clemens. I'm a member of the State Board of Education.
I'm Alan Taylor. I'm also a member of the State Board of Education.
And to my left is Assistant Attorney General Baron Cunningham. I'd like for the council to introduce themselves.
I'm Attorney Deborah Stevenson. I represent Vice Chair Kevin Martin. That is Chair.
Morning. My name is Michael McKeon. I'm the Director of Legal and Governmental Affairs for the Connecticut State Department of Education.
Peter Feinstein. I represent interveners concerning citizens' parent family.
Good morning. We will now commence with the Killingly impartial inquiry. Attorney Stevenson, I'll turn it over to you.
Thank you. And I do have a few preliminary matters. One, I'd like some clarification on why we're here and what exactly we are presenting. The reason I'm asking for clarification on that at this point is because the 1014 statute, they're regulated also by statutes 4-176A and 4-184, the U.S. statutes. Under 4-177, there is an opportunity for a hearing after reasonable notice, including a short and plain statement of the matter concerning. And we don't have notice of the short and plain statement of why exactly we are here. We have been asking for months for clarification of that. And the last document pleading that Attorney McKeon filed, an omnibus memorandum in opposition to our motions, he indicated that the hearing code is not a vehicle for litigating the findings that were set forth in exhaustive detail in the CSDE October 24th investigation report. Well, that's what we're here for, okay? But apparently, Attorney McKean indicated that Killingly with a failure to implement the educational system state at this juncture is settled. I'd like to know from the hearing panel how and when it was settled, especially by the hearing panel, that those allegations made in the April 5th complaint and Attorney McKean report, all those allegations are now settled. Why? Just because he stated them? Or is this an opportunity for proving them? Which is what we thought, which is what due process allows. So that's the first question. Why are we here? Are these allegations settled or not? Because I need to know how and what it is I'm supposed to be presenting. He indicated also on final thought that what we really want to do is examine Killingly Board's present and the future implementation of the educational state. Well, where was that all along? A year and a half.
Okay, Terry Lawton.
Yes.
Thank you. Good morning. There's something ironic about the fact that Attorney Stevenson, who has successfully delayed this hearing for 11 months, for a hearing date which was supposed to be January 12th and 14th, is now claiming, I don't know what I'm here for. I think it's been made abundantly clear what the subject matter of this hearing is. Initially, the state conducted an investigation and issued a thorough 32-page report, which was dated October 24th of 2022, which detailed in great detail and based, frankly, overwhelmingly on the information that Killingly itself provided. It's a failure to implement the education with the state. That was the State Department of Education's determination. That was our finding. Their failure to, quite frankly, respond at all to their students' needs. This State Board of Education, having reviewed the report, having listened to the recommendation of the commissioner on November 2nd, 2022, passed a resolution determining that there was a cause to believe that failed to implement the education interest of the state. Now, thanks to Killingly delay tactics, a year later, we're in November of 2023, and the purpose going forward is that still a state of affairs at Killingly? Has Killingly rectified its prior deficits, and are they now implementing the educational interest of the state? This is an inquiry. That is the term used under the regulations. This board had determined over a year ago that there was cause to conduct an inquiry as to what Killingly is currently doing. Attorney Stevenson wants to do the fact that was reflected in a particular motion to call me as a witness, which was clearly an 11th-hour attempt to qualify me as the department's counsel. That's water under the bridge. That was looked at back when Killingly had ample opportunity to respond. Again, the bulk of the report is predicated upon the information Killingly itself provided. There is really no function to be served now to go back and say, well, what happened a year ago? We're well past that. We are now looking to see, have they addressed the issues that were found to be lacking, or the services that were found to be lacking over a year ago. As I have also indicated in my filings, my job here is not to prove that they had failed to implement the education, that they are currently failing to implement the education of the state, nor is it my job to prove that they are. This is an inquiry, and the panel has recognized this by requiring Killingly to go forward to establish to the panel something that they've had 11 months to do by coming to the department saying, hey, this is what we're doing right now. Let's see if we can get common ground. They have failed to do that. So we are here now for Killingly as part of this inquiry, as the thrust of this inquiry, as the subject of this inquiry, to determine whether or not Killingly is currently addressing and implementing the educational interest of the state. I think that's been very clear for months now.
Ms. Stevenson, this impartial panel of the State Board of Education has responded numerous times to your questions, and we are here to check on and for an inquiry of the implementation or lack of in Killingly, and that is why we're here. That is our sole reason. And we're asking you, please show us that.
I appreciate your statement, okay, but I need to address some untruth that's been beginning to
Can we just get started on the inquiry itself now that we know why we're here?
With respect, Lynn, I'm here because I represent my clients, and representing my clients means I'm upholding the law, okay? And the law allows due process. And this is not due process right now. When I am not even given for 11 months, we have tried to get the specifics of what is the problem here. Now, there's an untruth about, Killingly was delaying tactics for 11 months. No, we filed appropriate motions, about 12 of them. And this hearing panel only last week came through with some votes on many of those motions. So we were not delaying anything. We were exercising our right to due process under the law and what is allowed. And the hearing panel, as you know, made some of its decisions behind closed doors. And that's why we filed 3 complaints against the illegal meeting. And those are still standing. We have followed the law and we have exercised our rights under the law. And our right under the law is to know a short and plain statement of the matters asserted. Attorney McKean has stated in his omnibus and all his other pleadings that Killingly has violated, the rights of the educational interests of the state, et cetera. Okay, well, normally under due process, when accusations are made, there is whether you call it an inquiry or a hearing. But when the hearing takes place, the accuser goes first and lays out a case, after which the accused gets to present a defense to those accusations. Here, at the last moment, Attorney McKean has stated all along these allegations were floating out there. It is also true under our statutes and regulations that Attorney McKean has the burden of proof. We don't have the burden of proof. Attorney McKean has the burden of proving the allegations made in his report. Now, when you make a report, an investigation report, and you make some allegations and findings of facts, reported facts in your investigation report, and you present it to this board, and the board says, well, we need further inquiry about that, and the inquiry is scheduled, then the fairness under due process means that Attorney McKean presents his case about how he found the findings of fact, with what evidence, when, how, where. When it comes down to it, when we ask for a bill of particulars about that all along, so we would know how to proceed in any defense, that's denied. We are not allowed to have any bill of particulars about how, when, where those findings of fact were made, how, when, and where we Killingly violated any other statute or provision, or some of the claims outright untruths that we stopped looking for staff. We stopped asking for, hiring of a psychologist, whatever these facts were. Where did those facts, what is the basis? What is the evidence for those facts? We're entitled to that. And that's why it's his burden of proof. Nonetheless, that's why I wanted to believe now. If you're believed now, you're stating that it is not his burden of proof, and that we must go forward nonetheless, regardless of what the statutes say, regardless of what the Constitution says about due process. Is that, I need clarification on that. Is that what you're stating?
Pete Feinstein, would you like to comment briefly?
I'm not sure I see any reason to get into this, except to say that from the point of view of the concerned citizens, we do not agree with Attorney McKean that it's water under the bridge. For 2 years, students in Killingly have not had the mental health services they deserve. And it seems to us that there ought to be some remedy for those 2 years of lack of services. As the issues of who goes first and burden of proof, I'll agree with Attorney McKean on those issues.
And yeah, these are allegations that are thrown out randomly with no facts behind them. Where, putting me for 2 years, not provide anything to its students.
I don't know what color the sky is in Attorney Stevenson's world, but in this universe, due process is more satisfied here. The October 24th, 2022 report was 32 pages long. It contained, I believe, 64 enumerated, actually more than that, I apologize, 67 enumerated paragraph of finding, factual finding. Each factual finding was directly linked to a document, a statement, an affidavit, all submitted by Killingly. There were some documents that were within internal TSD overthrown to the public, such as the rating of chronic absentees and so forth and so on. Every factual comment, or statement, or finding is linked to a document or a statement. This was such a roadmap to Attorney Stevenson and to Killingly as to what the deficits were in Killingly's program and their failure to implement the educational interest of the state. It could not be more overwhelmingly detailed. Anyone could simply look at this and say, all right, this is where they found fault. We are now going to go in there and this inquiry and establish these situations no longer exist. That is their burden to establish. For her to state that she's somehow being deprived of due process and has no clue as to what's going on in this case, it's just totally baseless.
And I would say that
I do want to state that the State Board of Education, back on November 2nd, 2022, had reviewed the report, the 32-page report that Attorney McKeon refers to. And we voted as a full board to have an impartial hearing, an inquiry for Killingly. That is where we stand today. That is what we'd like to get started with.
is. It doesn't matter how long the report is. It is still a report to the committee on some allegations made. And the state board, you're correct, did agree to adopt that report and begin an inquiry into the allegations made. That does not change the burden of proof to the accused. To the contrary, that begins an impartial hearing where the person who investigates and comes up with a report to the committee has the burden to go forth and explain how, when, where, and why those allegations are factual.
Ms. Stevens, so this panel is ready to hear any evidence that Killingly is willing to present at this time.
Okay, I
I'm not
understand
here
that.
to answer your questions. We are here for your presentation from Killingly.
Okay, and I would formally on the record state that I object to having to proceed without knowing, first of all, what's going forward when we are the accused, and it is not our burden of proof. Right?
Objection is noted. Can we start now, please?
I had a couple other preliminary matters. One,
No, I'm not here to answer questions. We are here to begin the impartial panel on the inquiry into Killingly, and I would like that to begin now.
I understand that, but I need to make a record, especially for appellate purposes, if nothing else. But number one, I'd like to know the intervener status, because I'd like to know what the limitations are on the intervener in these proceedings. That has not been clarified either.
Ms. Stevenston, can we please start?
Are you denying me due process to know about what the status of the intervener is and how this panel, if at all, is limiting the intervener's participation in this inquiry?
The interveners moved to be named as an intervening party. That motion was granted for a party. I think that's as straightforward as it can be.
And under 4-177A, the petitioner's participation shall not impair the orderly conduct of the proceedings, and the panel may limit the intervener's participation. Not to mention that under that statute, the panel shall define the intervener's rights to introduce evidence, to argue and cross-examine on issues, and may further restrict participation of the intervener to promote the orderly conduct of the proceeding. I'd like to know if, how, and when the intervener is going to be restricted.
This question should have been raised a long time ago, and it should not have waited till then, till now. I think the 32-page report that Attorney McKeon has referred to, that we've all seen, that was dated October 24th, 2022, is what brings us here. And I would like you now to start for Killingly.
Well, I am going to comment on that because the intervener himself had asked for a preliminary hearing to determine just those kind of rights. And that was nothing decided that I'm aware of on that request. And you're asking me to proceed without knowing who has the right to speak when, what evidence, whether he has the right to cross-examine anybody. What is the panel's decision on that?
He has full rights as an intervening party. And at this point, could we please just start the inquiry? We made it very clear over a month ago that Killingly would be presenting first. We are all here to hear that. Could we please begin now then?
And again, I'd like to know when the panel made the decision that he has full rights.
I think when the panel grants the motion to intervene.
Excuse me, Attorney McKeon?
But I think when the intervener's motion to intervene was granted, that established that they were an intervening party, and if the party would have full right.
Again,
And the bottom line here is that we're not here to answer questions. So again, I'm asking again for Killing, are you ready to present?
again, I would object two things. One, if the decision was made outside of this hearing, again, that's an illegal decision on the intrusive status. There's nothing defined about limitations in the granting of that motion to intervene. And number two, I would object to having no answers whatsoever to the preliminary matters that should be decided in a public committee before the hearing begins.
And your objections are noted. Can we please start? Thank you.
There's one final thing I need to bring up, and that is the evidence. All of us submitted potential lists of evidence. And again, there was no preliminary matters discussed about the evidence. I'd like to know if all of our evidence is now admissible on yacht, or are we going to go through whether what is admissible or not? What is the panel's decision on that?
Stevenson, if the parties had not worked out what evidence is allowed, each piece of evidence will be, you have the right to bring up each piece of evidence and we will challenge it and we will determine it at that time.
Well, I am offering all of our evidence as admissible at this point. Are there any objections to any of those? Because I have objections to some of theirs. I'm asking if the other parties have any objections to any of ours.
Mr. McCann?
Killingly submitted 504 pages of exhibits, almost all of which are irrelevant. Some of which really deal with things that occurred years ago. So I think it would make sense. I'm not saying that about all their exhibits, but I would suggest that as the panel has stated, we can just determine that on a case by case basis.
Okay, thank you. Mr. Feinstein?
I agree. I mean, I'm delighted to allow Killingly to demonstrate the relevance of their exhibits.
Thank you. We're ready to begin. Thank you.
I have objections as to some of their evidence I'd like to put on the record and have a determination made.
Well, they haven't been offered yet. We exhibit for exhibit sets that could possibly be submitted during the course of this hearing. It would seem to
You
be-
can offer those objections when the evidence comes up.
I'd like to know how they're going to, how this is going to be. We are presenting these first. What is the procedure?
Stevenson, could you raise your mic a little bit so it carries better?
We are here today to hear from Killingly. And that's how we're going to begin, is to hear from Killingly.
And again, out to me, there's no real particular. We're going to present our case. However, I object. This is all backwards. This is not due process at all. And I object to our rights being violated in such a manner.
Objection noted.
I recall as my first witness, Vice Chairman of the Killingly Board of Education, Kilmore.
Kelly, would you raise your right hand, please? Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God? Thank you. Would you state your name, ballot, and your address for the record, please?
Okay, it's Kelly Martin, Martin, 339 Hotford Pike, Bayville.
Thank you. All set.
Kelly, how long have you been on Board of Education?
For 2 years now.
And was that before or after the Roman generation?
That
I'm
was,
sorry, I didn't hear you.
Before or after the vote on generation?
Okay, you're gonna have to raise your mic a little, and Kelly, you need to speak into your mic.
it was before the vote that I started.
Okay. And can you tell us, to your memory, how that vote came about?
It was presented to us through our former superintendent. He presented it to us at a meeting. And we had a presentation by one specific organization.
And did the board ask for a proposal for generations, or how did that proposal get to the board in the first place?
He proposed it through a grant, which we hadn't known about at the time. Just brought it to us.
Okay.
I think he may, I was in leadership at that time, so I think he may have brought it to leadership in a meeting. And then it got presented to the full board there.
And what did the board do after the presentation? Was there public comment? Was there any discussion about it? How did that occur?
The board wanted to take a step back, do our research, learn about scope of what was happening. And so we did. We had a lot of public comment. We had letters sent to our emails. There was a lot of discussion.
A lot of discussion with the public or with the board or both or what?
A little bit of both.
And then what happened before the vote? How did you proceed before the vote? Was there any other public meetings or public?
There was one, we had requested community input. We wanted like a community forum, a community meeting, so we could sit down and discuss with both sides. There's always sides of the community. We wanted to be involved with everybody involved. And the superintendent scheduled the meeting, but he scheduled it as an informational meeting. So we weren't really allowed to, the board wasn't involved. We weren't allowed to have that back and forth with the community. So it was basically the same presentation that we had received from generations at our board meeting.
And why wasn't the board allowed to have that back and forth?
We're really not sure at this point. We tried to cancel the meeting because it was something that was already had, and the superintendent refused.
Were you advised that you couldn't participate? With the public?
We advised that we could not participate.
Who advised you on that?
Our attorneys at the time should have been a good one.
And so, but you did receive public comment at meetings, and you considered the public comment.
We did.
So far,
Yes.
okay. And what was the vote on generations in the end?
It's the majority vote was no.
Okay, and what was your vote on that?
I voted yes.
Okay, and was it a bipartisan vote?
It was bipartisan.
And was that vote because you were deliberately indifferent to the mental health needs of students?
Objection, lady.
Absolutely not.
Objection, don't answer until.
It was not leading. I asked because this is a quote from the allegations in Attorney Feinstein's complaint. And
Hold on.
What?
So administrative hearing will allow it.
I didn't finish my comment.
The objection is overruled.
I was replying to Mr. Feinstein.
But I have a right to comment on Attorney Feinstein's objection.
Objection is overruled. The answer.
Apparently is overruled too. I can't comment on it.
What is the purpose of it if your objection is overruled? The answer.
The question was, the vote was the vote because of quote, that the board was deliberately indifferent to mental health needs of the students.
Ms. Martin, can you speak up or move your mic closer to? Because I
Did the board refuse to adopt any interventions to address the needs of the students?
Never.
Did the board choose not to respond at all in any meaningful way to students' needs before or after the vote? Did the board and its staff, staff of the administration, know that there were students in need before the vote?
Yes, post-COVID, and this was part of my yes vote, was post-COVID, it was something that needed to be addressed more so than in the past. So the staff was aware, and I think that's why the superintendent came to us.
Okay.
Ms. Martin, I just have a question about that. What knowledge did the board receive that it was needed? Where did that stem from, that you received the knowledge that this health center was needed?
We didn't know that it was needed until it came before us with the vote on generations.
And is it true that it was a survey that was used to survey, a student survey that, to disclose this?
Yes, correct.
Morning.
Ms. Martin, you said. Can you hear me?
I can.
That you and the board wanted to understand what the scope of what was happening.
Correct.
What does that mean? Context.
Basically, I guess that means we wanted to be able to look over the survey. We wanted to be able to do our research and find out how this came about. We have to be informed, right? And it just came to us all in basically one of the meetings. So we wanted to just get the facts, find out what was behind the survey, where the survey came from, who sent out the survey, what was involved, and what we could do. What's the problem?
And yet there was no knowledge of a mental health crisis before.
I mean,
Presentation.
personal knowledge, we knew post-COVID, there were, we knew that mental health needed to be addressed, but no knowledge from the school system. Nobody came to us and said, there's a crisis right now, until that very.
The knowledge, the administration and the staff, were they aware of any of the students' mental health needs before the vote and after this?
Yes.
How do you know that they were aware of that?
Well, I know because we have amazing staff. They keep track of everything. I know they knew through the survey, but I think post-COVID, we had more visits to the nurse. We had more visits to the school counselor, so they knew that we were leading up to needing more help.
And before your vote on generations and before the pandemic, were the students' needs being met?
Absolutely.
How do you know that?
I know that because we never received one complaint from one parent. We did have a counseling center in there prior to COVID, which actually ended up getting taken out because the kids were in school. So I do know that we never received one single complaint prior to this temporary.
And the prior contract that you had with a healthcare service, was that Discovery?
That was Discovery Counseling.
Okay, and that's it. Our Killing League Exhibit 1 is the contract with Discovery, and I would offer that as an exhibit. Useful.
Please repeat the exhibit.
Killing League Exhibit number 1.
Exhibit 1, CRQ survey.
I'm sorry. Let me get the right number here. The contracts with Discovery.
It's 18.
Yeah.
Exhibit 18 is offered.
Any objections from council, Einstein?
I'm not sure what the relevancy of it, this document from some years back is to what's going on in Emily today, but that's fine. The bar, I don't object.
Again, the allegations were made.
Thank you.
The allegations were made.
Submitted as a full exhibit. Thank you.
The allegations were made that the Killing League Board had not done anything to meet the needs of the students prior to the survey.
It has been admitted. Thank you.
Kelly, did Kelly Board of Education have sufficient resources to meet the needs of the students prior to the vote?
We did.
And after the vote?
Yes, we always have made sure that we've had plenty within our budget.
And
Ms. Martin, can you describe those resources for us prior to the vote and how they stand after the vote?
I guess she just brought up the discovery counseling, which we had prior to my coming on the board, but I know we did always have that help. We've always made sure that whether it be crisis intervention or a school psychologist or a guidance counselor or whoever may be available, staff, administration, the children have never not been taken care of. We have outplacement. We have help from, I have notes here because I don't have everything in my mind. It's hard for me to keep it all in there. I don't work the day to day. But I know we have all kinds of interventions for any student that needs help, regardless of whether we're fully staffed or not. They've never been left behind, ever. We do.
Yeah, the survey did not reflect that. The student survey did not reflect that.
And I think that student survey probably doesn't reflect it in all other communities too. Post-COVID, it's been difficult for students. I don't know exactly how to answer the question on the survey. I know it was an anonymous survey, so we have no way of knowing who those students were. And we're in a different situation.
I don't think there's an importance of knowing exactly who the students were. I think student voice is student voice.
Yeah, absolutely. I'm not denying.
What about after the pandemic? What changed? What kind of resources were added?
Okay, so we did hire a director of mental health and wellness services. She's been amazing. Right, she can answer better than I can what's been implemented, but we did create her position to make sure that all of these matters were being taken care of and looked at fully.
And what is her name?
Her name is Kathleen Cody. We hired a new superintendent who's been amazing in making sure that everything's taken care of. We have a new head of pupil services who is implementing new initiatives for special education. That's been amazing. We gave really good raises. We went into our personnel committee and we gave raises and to all of our staff. I believe we're fully staffed now because of that. Because that was an issue too, not being fully staffed. So we now have all our school psychologists in place, guidance counselors, our 504s, our IEPs, everything's being taken care of currently. I think we're one of the higher paid districts now, actually, as smaller districts that are comparable to us.
Have you considered or did you do another student survey?
We have not. We do have one going out at the end of November.
so in the CREC survey that was done, that was the first survey, correct?
First survey that I know of during my term.
And that survey was anonymous, correct?
Correct.
And in that survey, to your best of your recollection, ask any questions about what the Hillary Board of Education or administration was doing for interventions for the children?
I don't believe so. No.
So was this survey just a survey of the students' attitudes and concern?
For what I know, yes.
So that survey didn't reflect actually at all what, if anything, the Hillary Board was doing to help the students.
It did not.
There was an allegation that the board presented no evidence that it sought to increase staff, psychologists, social workers, or counselors. Is that what you were referring to, that you had been?
We've always addressed that. We always address everything that needs to be addressed. So to hear that, I mean, we literally do this as volunteers. We come in with all good intentions. There is nothing malicious behind any of the board members. So to be accused of not addressing staffing issues and mental health needs, it's saddening. It really is. It's saddening and it's frustrating. We only have their best interests at heart.
So in your meetings on the budget, were these issues discussed about social workers, counselors, parent psychologist.
Yes.
In our district. Yes. Can you explain some of the discussion?
We just, basically in budget process, we just discussed the money that we're going to need to make sure that we have enough to be fully staffed for the next year, and we made sure that we were.
And, the other allegation was that Killingly is basically in a mental health desert. Can you tell us, what other mental health, providers or vendors that Killingly may, use or that are at least in the area so that students' needs can be met?
Okay. Off the top of my head, I'm gonna say we have United Services, we have Inlet Counseling, we have Silver Linings, we have Generations, we have Day Kimball Hospital, we have CHR. And those are just the 6 that I think of off the top of my head. There may be more.
Ms. Stevenson, can I ask a question? When you say mental health desert, are you talking about the lack of issues around mental health or the lack of providers addressing mental health?
To my knowledge, to my memory, the allegation was made that these students are in desperate need and there's a crisis, in part because there is Killingly is in a mental health desert area, meaning there are no other resources available.
Providers, not people with
Correct,
mental health issues. That was my question.
correct.
Thank you.
I just have a follow-up to Mr. Clemens. The long list that you were saying about the resources available. How well aware are the students of these resources?
I couldn't answer that question other than to say I know flyers and whatnot go home to parents. So I do know that
Is there any indication of students that use these resources?
yes, absolutely.
And how do you obtain that?
Through staff.
Sorry, so you involved in the day-to-day, going on within the administration and the staff?
I am not.
The staff periodically report to the board about, what they're doing about the needs of the students.
Yes, most meetings are good.
Ms. Stevenson, when you're referring to staff, are you referring to the superintendent and his administrative team?
Yes. Okay, so you identified 6 other healthcare facilities in the area. Do you know if the administration or staff has engaged the services of any of those facilities or other vendors, either before or after the vote on donations?
I could answer that better than myself, but I do know that, I believe we were involved for some time with EastCon. Maybe even now, I'm not positive about that, but I know they've been reached out to EastCon. That's
Do you know if there have been agreements made, memorandums of understanding, or contracts made with any of the outside providers?
yes, we have a memorandum of agreement right now with CHR. They are in 2 of our schools.
Do you have, before the vote on generation, were there policies in effect dealing with mental health, crisis intervention, suicide prevention, et cetera?
We do have policies in effect of safe climate school prevention policy. Okay, and another one, I do know.
The book is over there. You need to refer to it, the exhibits. Going to refer to, he's referring to, Kimberly Exhibit 4, the suicide prevention policy, and the Exhibit 5, for the rating scale, suicide rating scale, and suicide intervention form, Kimberly Exhibit 6. Are those some of the policies you were referring to?
Yes,
Okay. And do you know how long those policies have been in effect?
I believe that from what I know, they were last updated in 1990. So I know they've been in effect at least that long.
Okay. And,
Attorney Stevens, the door was closing, I didn't hear.
I know they've been effective since at least 1999. That was the last time that our policies were updated.
if you would, I don't know, if you would, refresh your memory at all, but there was a date of 2004, does that break your memory on any of those policies?
as the last update?
That's we call it.
I do not recall. That's the last I remember seeing is 1999.
And also, the Safe Schools Climate Policy you mentioned, that's in Killing Exhibit 10. Is that what you were referring to? Yes. Okay, I would ask this. Killing Exhibit 4, 5, 6, and 10 to be listed by the people.
Any objections?
I didn't get the name of exhibit 6 written.
Exhibit 6, suicide intervention.
Thank you.
So there are policies and then there are forms that the staff or the students fill out in order to implement the policy when we get an indication of a student who may be in need of these services or maybe a suicidal ideation.
What were the exhibits you wanted? It was
4, 5, 6, and 10.
and
The 10 is the safe school climate.
yes. I don't really have any objections. I just I don't know what exhibit 5 is.
It's a suicide rating scale.
I don't. That implemented, but who did who implemented that? I mean, what we do is that board of policy was meant the board wouldn't be expected to, but is it used within the district by
By the administration and staff.
What's that?
Okay, we don't have other witnesses that go into more detail, but the policies, especially the safe school climate policy, identify the people who are to be notified for what the staff is supposed to do in these situations. For example, if a student is, if there's any teacher or any person on staff has any idea that a particular student may be thinking about suicide. If there's a crisis intervention, the student is not left alone, there's certain procedures these policies describe that the various staff members are required to do and have done in the various situations. At that point, then they either, a counselor, social worker, refer them to a higher level of need in the community, 211, it's called. These are procedures that are all described in the policies and have been in effect for years.
Ms. McCann, do you have any objection?
Well, the technical matter, no foundation is complete. We don't know that these are the exact documents that are being used. And this witness, who's been on board for 2 years, is not in a position to establish that basis. So on the basis of lack of foundation, I do object.
Again, these have been on public record, on public websites for years, and they can be authenticated quite easily. I would ask that you get administrative notes be taken of those policies, and they be in the.
Ms. Stevenson, do you have witnesses that can lay the proper foundation?
I have other witnesses, yeah,
Because Ms. Martin has already indicated that she does not have that expertise in these particulars, so perhaps.
I would simply suggest she is the board member, a board member. The board has voted in these policies. These policies are in effect under her vice chairmanship. I think that suffices as her being able to authenticate. Otherwise, we'd have to go back to 1999 or board member to authenticate them. I think that's.
Well, I thought you said you had someone here that will.
We have staff members who have utilized them. But what I'm saying is these are board policies, not staff.
I'm aware of that, but it's not a board policy that Ms. Martin herself would see or even fill out. I mean, this is not a form she would be involved with. Mr. Feinstein, go ahead. Oh, okay.
I'm listening. I do think that a custodian of records could authenticate these as current active documents.
She is a custodian of the record. She is a board member, a vice chair of the board. These are board policies. They are right there. She can look at them and tell you they are the official board policies. I think that's what she.
Right, Ms. Stevenson, we will conditionally admit them and later have someone that can lay the foundation for them.
And who would be acceptable other than a board member for your purposes?
The CSD would take the position with respect to 4 and 10. They are stated as board policies. This is the part of the vice chair of the board. You have no objection to the policy.
And, Martin, if you could open that book and look at exhibit 5, the suicide reading scale.
Attorney Feinstein, is your objection just to exhibit 5? Do you have any objection to the other exhibits?
Well, 4 and 10 I recognize because they're publications of Cave that are
No
not.
objection to those?
Well, 4 and 10 I have no.
So 4 and 10 are admitted as full exhibits. And what about exhibit 6? An objection?
Yeah, that would take an administrator on.
Okay,
Is supposed to say.
you're objecting to exhibits 5 and 6, is that right? Okay. Attorney Stevenson, do you believe this witness can lay the foundation for exhibits 5 and 6?
I do, because she's a board member, they do.
You may proceed.
And I'd be for exhibit 6.
Exhibit 5 first, if you could.
Okay.
Okay. Have you seen that before as actually in the board policy manuals?
This is 5141.5, the suicide prevention and intervention. And yes, I have.
And because you mentioned the number of that board, could you explain what the number means?
Each policy each bylaw that we have is listed by number, I believe. If I'm quoting honest, I believe that it all comes from Kate. And that's how we list the numbers.
Okay, so the first number, the 4-digit number,
Yes,
is that the main policy?
yes,
Okay, and the point whatever
is
or,
is a sub policy that falls under.
okay, so these are other ways of implementing the larger policies that, that's correct?
That's correct.
Okay, and so is that, are you aware, and do you know that that's part of the board's policy that at some point a board would have voted on?
Objection, could I, Attorney Stevenson, please specify which document she's talking about? The numbers are document 4 and document 10, which are the Cave documents. Document 5 is a rating form by somebody, the Columbia Suicide Severity Rating Scale.
Perhaps Attorney Feinstein wasn't paying attention when I asked, is the exhibit 5, which is listed as, could you read the number again? Exhibit 5?
It's 5141.5 suicide prevention and intervention. I believe what he's speaking of is.
Well, actually, I'm sorry, my exhibits from Killing Lake, exhibit 4 is 5141.5. Exhibit 5 is the rating scale that Attorney Feinstein.
I think you're actually correct. I was doing it backwards.
Yeah.
So
I
it
think,
is exhibit 4. That's what it is. Yeah, it's exhibit 4.
The whole process again on exhibit 5. I don't know, okay.
So I think we're speaking of exhibit 4. Exhibit 5 is that Columbia Suicide Severity Rating Scale.
What does that say on the top of that? Well, does it have a number?
It says line 22.
Okay, it does not have a number as relating to the board policy.
Exhibit 4 does, yes.
Attorney Stevenson, do you want to approach the witness? Do you think that would help?
No, that's okay. We can have another witness. Are you familiar with that exhibit 5 as part of the board policy?
I am the chair of the policy committee, so yes, I've been through all of these, and yes, it is one of our lives.
Okay, so that's part of, what, could you read the number again of exhibit 4?
5141.5 suicide prevention and intervention.
And so you know that document that it appears as our exhibit 5 as part of the board's policy.
Yes, I do.
Okay. And, could you, after that, maybe that exhibit 5 being minute on that basis. And we now turn to exhibit 6, the suicide intervention form.
There's nothing on the face of the document that indicates that it's part of Kelly's policy.
Does she just testify
They
that?
just did testify, so they will not be. Exhibit. And the full exhibit.
Exhibit number 6, the suicide intervention form, you have that article again. Okay, are you familiar with that?
I was not in the past. with the 10-4B, I became familiar with it.
Okay. Do you recognize that as part of the policy of the Building Board of Education?
Yes, I do.
Okay. I would ask that it be on the same basis.
Okay.
Exhibit 6, sorry, exhibit 6 is now a full exhibit. Thank you.
If you could turn to exhibit 10, that's fine. Do you recognize that document?
I do.
Okay, is that the safe school climate policy?
It is.
Okay, and what number is that?
That is 5131.911.
And you're familiar with that, or that policy is part of the board policy?
I am.
I would ask that that be, exhibit 10 meeting.
Objection.
Whatever he wants to do.
Okay. I'm going to ask you to another comment. When you were, after you voted, I remember, as you voted on generations. I did. Okay. Afterwards, did you say that's it? We're not doing anything further with regard to the mental health needs of the students?
No, we did, say that we were gonna adjust, ultimate suspensions.
And how did that happen?
We created an ad hoc committee.
And when was that out?
That was, I can't give you the month, but it was shortly thereafter.
After the voting generation?
Yes.
And did you serve on that ad hoc committee?
I did.
Okay, what that happened?
I was the chair.
And what did you do in terms of?
We had discussed, some things like peer counseling and busing and all of that, but our ultimate goal in the ad hoc committee was to interview other organizations. It should have been brought in the very beginning. We should have never brought just one organization. So we wanted to look into other organizations so we could kind of meet in the middle and represent both sides of the community. And that's what we did. We interviewed 2 great organizations.
And what were those organizations?
So the first one was CHC. We interviewed CHR and Civil Alliance.
Okay, and how did you get those interviewed?
Well, the very first organization, CHC, I met with them via Zoom to get the information to bring to the ad hoc committee. Ultimately, I did bring it to the ad hoc committee. We found that CHC was an amazing fit for Killingly. And we started contract negotiations with them. That was going because we had some interference from Harry Feinstein. We had some interference from a current board member where they're going to the media saying, this is too little, too late. We're not okay with this. They're bowing to the political affiliations of the board, which was never true, not for 1 second. Was that ever true? They didn't know our political affiliation. They never asked us. We never talked about it. We simply had the children's best interest at heart and the full community's best interest at heart. We don't do this for any other reason. So we wanted to come in and say, okay, we voted no on generations, but we want to at least look at the other organizations and see if they're a good fit for us. And that's exactly what we did. CHC ultimately backed out. I had a conversation with them when they did. They emailed me and said, we're going to back out of this. I had a conversation with, I believe it was Yvette Highsmith. And she said, we don't.
Objection, hearsay.
We don't.
Do you know why CHC backed out?
I do.
And what was the reason?
The reason was that they felt like they were going to be welcomed into our community with open arms. There was too much controversy. They didn't want to be accused of being political. It was just too much for them. They didn't want their reputation ruined over all of the media and the local radio station attacks. And there's been so much attacks in the last 2 years. they just weren't interested. And I don't blame them.
Really quickly, sorry, Ms. Martin,
Yes,
you mentioned twice both sides of the community.
yes.
Can you talk about that a little bit? What does that mean?
I can. So we had one side of the community who was very, very passionate. And I understand that they were very passionate about bringing in this one organization, Federations. And we had the other side of the community who was saying, we are concerned with bringing a mental health clinic into our schools. We're concerned with parental rights, parents not knowing that their children were being treated. So we really just wanted to make sure that we understood fully what a mental health clinic coming into our schools is going to involve. And so that's when we took a step back and we kind of wanted to make sure that we were representing both sides of that.
So this was centered on this one particular agency, or the fact that there would be some levels of intervention that parents seemingly wouldn't know about?
I think it was
All of it.
all of it as a whole, yes, correct.
Was there any particular, where did the students play in these sides? Is there voice from the students?
There was a voice from the students as far as public comment. We did have students show up to public comment and speak for the mental health clinic.
So getting back to CHC, what was the controversy in the media?
The controversy in the media was, I guess basically when we had people coming out saying that this isn't good enough. CHC isn't good enough for us. We want the original option and the original option only. This is too little too late. We don't want to have the parent opt-in portion added to the contract. And then there was the accusations about, I don't know, affiliation, a lot of it.
What do you mean accusations?
Accusations that the only reason that CHC was an option to us was that because they were willing to bow down to our political affiliation. Absolutely not. And the reason I think that came forth was because we were referred to CHC through the House Minority Leader, Laura. So that's why they believe this was all political. He was just trying to help. Me, as the chair of the ad hoc, I said, what are some really good, strong organizations that we could bring in? Federations had some not so good reviews online. So we wanted to bring in somebody really strong for Killing Me. Took that step back and said, who's really strong? And Laura said, CHC is really strong. You should speak with them. And that's what we did. So it wasn't political. It was just somebody we know giving us some good advice.
And did you open up that CHC conversation in the ad hoc committee?
We did.
Okay, what happened there?
We had the meeting, they had a presentation, they gave us an amazing presentation. And we had the opportunity to ask questions. The board member who attacked them asked no questions in the ad hoc, maybe one. And then went outside of the ad hoc committee and started emailing them and asking them questions, and then went to the Norwich Bulletin, and then went to the local radio station. And that's what started the controversy. It should have all been discussed within that ad hoc meeting so that we could bring it to the full board. And it went outside of the meeting, and it caused a lot of problems.
And is that, is that why, one of the reasons why CHC pulled out?
Yes, I do.
How do you know that?
Because the person that I spoke with at CHC told me. Because I said it was, because we were in contract negotiations with them to make a few changes. And I called her and I said, does this have anything to do with contract negotiations? Because I was worried about that. She said, absolutely not. We do contract negotiations all the time with every organization that we work with. So absolutely, it had nothing to do with contract negotiations. So that's been another one of those truths that's been out there. Oh, it's because they were trying to negotiate on the contract, and they told me absolutely not. That is not true. It had nothing to do with contract.
So I think it was the negative publicity.
The negative publicity and the feeling of they wanted to be able to walk into our school system and say, we're welcomed by all the staff. We're welcomed by every board member. We're welcomed by the community. And they just didn't feel like that was gonna happen.
So after that, what did you do with that activity?
After that, we decided to look into two more organizations. So our Director of Mental Health and Wellness found CHR. She said she heard good things about them, and also Silver Lining. So separately, we interviewed both of them in the ad hoc committee, and we ultimately decided that CHR has given the best presentation. We really liked them, and we brought them to the full board.
What were the pros and cons of Silver Linings?
The pros and cons of Silver Linings, I think every single organization is very close to what the other organizations represents. And Silver Linings had the same pros and cons as CHR. And I think CHR just gave a better presentation. Did I answer that question?
Okay, and for CHR, and was how that proceeded in the ad hoc committee thereafter.
Once we decided we had the interviews, we went back to ad hoc, and we all decided that CHR was the one that we were gonna bring to the full board. We brought it to the full board. They gave their presentation to the full board, and we had a unanimous vote to put them not in just one school, but in two schools.
So
In what two schools is CHR currently? Is it still there? Correct.
It is, yes.
What two schools, please?
The Killingly High School and the Killingly Intermediate.
is generation supposed to be in two schools?
No, they were originally asking for one school, but we thought, being it post-COVID and whatnot, let's take the middle school students and help them out so they can move into the high school with more ease.
And that was your, the board's decision.
Yes, it was.
And then you subsequently came up with the contract agreement.
We did.
And when was that signed?
To remind me,
Approximately. Before school started?
before school started, yes, during the summer months, yes.
Okay. And how was CHR, how did they implement their services?
I know they started, as soon as we signed the contract with them, they started, working with staff to get out letters to the children who are most in need. And they suggested to us that that's how we should at least start it off, get those children treating over the summer, the ones that are most in need. And then when school starts, we'll send out a letter and get everybody else on board. So we did, we started over the summer with them.
So when the staff worked with CHR did not know the student at that, correct?
Correct.
Apparently staff did.
Yes.
Okay, and they already had in mind identification of certain students in need. Did that indicate to you that they have ways, even although a school-based health center is not, they have ways to identify students in need?
They do, absolutely, without a doubt. Our staff is never formed the harming on any of these students, not for any reason.
To your knowledge, when they have identified students in need, do you know if they have provided services to them?
Yes, always.
And how would those services be provided if you didn't have a healthcare center in the school?
They were provided through the school counselors, through crisis intervention, through 211, through DCYF, through outplacement referrals if necessary, but always taken care of.
So you have social workers and school counselors on the staff.
Correct.
Would they be the first intervention? And
I believe so.
okay, and then if the intervention didn't work, then to your knowledge, does the staff refer to other agencies, other providers?
Yes, they do.
Okay. So let me ask you another question, because this was not reflected in the investigation report. My knowledge, any of what you just described. Did Attorney McKean come to Killingly at all during his investigation?
Not ones that I'm aware of.
Did he talk to staff at the classrooms at all?
I don't believe that he did.
Do you know whether Attorney McKean talked to your social workers, counselors, or the school psychologists during the investigation?
I don't believe he talked to him.
Did Attorney McKean or anybody from CSDA tell Killingly specifically what it was doing wrong and how to address the problem during the investigation?
I know, we tried numerous times to have some sort of mediation. We wanted, I mean, a lot of money has been spent on this. We wanted a long time ago. We wanted somebody to say, okay, you've implemented this, you've worked really hard. You please the Department of Education. We understand that you're doing everything that you can. Let's mediate this. Let's tell you, we wanted them to tell us. I got distracted. He's rolling his eyes at me. We wanted them to tell us, you've done this, that, and that. And we think you're doing a great job, but we need you to do this also. We never got any kind of answer. We never got any kind of mediation. We've gone through the last 2 years not knowing what else we need to do. We're doing everything. We have an amazing
Ms. Martin,
school
you
system.
have read the report of October 24th, 2022.
I have.
Asking, thank you.
Would in that October report, was there any indication specifically how, when, where, or what exactly the school was not doing and could not identify the needs of the students or provide for them?
That's what I know of, other than the vote.
Okay. And, do you recall whether Kelly Lee asked the Commissioner of Education for specifics as to what Kelly Lee did wrong? How we read it? That question, but do you recall whether Kelly Lee asked the Commissioner of Education for specifics as to what Kelly Lee was doing wrong? We did review, okay, and what was the Commissioner's response?
The Commissioner's response was that we should approach our staff and speak with them about it.
So there was no indication that the Commissioner was willing to have a discussion with the board about how they needed this. And would speaking with your own staff help to get a resolution with a PSDE or a Commissioner?
No, because our staff believes that we're doing everything that we should be doing.
And is to your knowledge, the staff was meeting the educational needs of the students and people living on generation?
Yes, absolutely.
Because they could identify the needs personally?
Correct.
And they had the policies in effect?
Correct.
And implemented them? And refer the interventions to the social worker, counselors, and outside providers as needed?
Yes.
So, based on your prior testimony, going to ask this to confirm, did the board not consider any alternatives to generations? No. Okay, they considered. When you testified,
Yes.
did the board present no evidence that after rejecting generations that requested or sought presentations from other operators?
I'm sorry.
There was an allegation, let me rephrase that, there was an allegation made, probably in the October report, and the board presented no evidence that after it rejected generations, it requested or sought presentations from other school-based outside operators.
Absolutely untrue. We presented an amazing amount of evidence that we're doing everything that we can.
So getting back to CHC, I want to refer to filling the exhibit 7, I believe, is that look at that, see if that's the contract with CHR?
Davidson, is CHC and CHR two different organizations?
Correct.
Thank you.
Ms. Martin, maybe you could say the exact names of those.
That'd be helpful.
So CHR is Community Health Resources. And CHC. Sorry,
It's CHCI. Community.
CHC.
I don't know.
Centers.
Community Health Centers and Community Health Resources. Okay, I have exhibit 7.
Okay, is that the CHR contract?
Yes, it is.
Were you involved in the contract?
I was.
And we got the combinations of your negotiations, that is. And by the individual and public.
Any objections?
Concern, this is an unsigned document, right?
Was the document signed?
It was signed.
Do you have one in?
We do. We do have a signed copy.
Just an oversight, bringing the unsigned documents. Ask that we move the signs for today's purposes. But it is signed, it is in place. And then after that, be recommended in the to
Let's exhibit 7, reflect the signed document.
Yes, it does.
Well, we've heard lots of discussion about negotiations with providers. I would, this is willing to testify that it's identical to the signed document, and then I'll withdraw any objection to it.
It is identical.
Back to my talk.
Exhibit 7 is admitted as a full exhibit.
I would ask you to go to exhibit 6.
Other than tax. 26.
Track report. The East Fund contract, is that what you have?
Now I have the correct report. As a, of exhibit 26.
It's the title of the exhibit.
On contract with only
27.
27.
Okay.
Here don't find.
Okay, I have it now.
So then we back up on
And
it. That reflects an agreement between Tony and Board of Ed and East Con.
yes, it does.
That would be for to mental health services for students, is that correct?
Correct.
And does that have a date on it?
It does 4/18/23.
And that's the latest.
Yes.
Do you know whether, the Philly board or the administration got entered into agreements in the past with, like, these on?
I believe prior to my term, yes.
And do you know whether they have entered into similar contracts with other vendors?
It's our final, yes.
I know that this document is entered into false.
No objection.
Clarification, signed by the principal of KCS. What?
That is Killingly Central School. That's our younger two.
The intermediate school, KIS.
Yes, and that would be grades 5 through 8.
KCS would be,
KCS. We have KCS, AMS. KCS would be 2 and 3.
kindergarten.
Kindergarten first. And AMS would be the next. Second and third. And then up to.
Okay, so
Second, third, and fourth.
I can do this like crosswalk, I can do it right now, but the question is whether this contract only applies to students at KCS.
I'm going to assume it does. Let's double check that. Contract for services. It appears as though it is just KCS.
Very good, no objection.
So that's a new contract that was signed.
It is.
It's admitted as a full exhibit.
Yeah.
Exhibit 27 is admitted as a full exhibit.
So is this indicative of contracts that you have seen, yeah, the board member, with other vendors, you've seen others that have been finalized. And that's before the vote. Correct. Consideration. And after the vote as well. Correct. As that indicates that was happening with renovations, correct? You were also. The board members, the board speak, or approve grant proposals. You do. Is that always been the case?
No. No, and we only noticed when, we found out that the superintendent had asked for monies for the SVHC, that we weren't aware of.
Right, not to generations.
And that was for generations. It was, they asked for $4,000 for furniture. The rest of the monies were spent on staffing.
Ms. Murray, what superintendent?
Superintendent Angeli, Robert Angeli.
Okay, so just to back up a bit, which is when Angeli, put in a proposal for grant money for the generations. That's right.
I believe it was prior to him. It was Superintendent Stephen Ryu. And then the transition was made, Ryu left and Angeli came in and he continued.
Okay, and that was no board involvement, is that right? No board involvement. No approval of the grant being applied.
Martin, was that against policy?
That was, it's hard, there isn't an actual policy. I guess in the past, a previous board had given all that to the superintendent.
Practice.
Without us.
It was practice.
It was general practice at the time, yes.
Has that general practice changed?
And that's,
Okay, and why did that change and how did that change?
that changed basically because this came to us as a lawsuit against the board saying, and we've had accusations saying they requested monies in this grant. Where are those monies? Because they turned down the SBAC, the first one. We decided that it's best practice for us to know what's these grants that are going through, what's involved, what's being asked for. The board should know, basically, I think. The power was handed over in the past and we believe that. We should know. If we're gonna be sued for something, we should know.
Before it's applied.
Before it's applied for, before the lawsuit comes before us.
Okay,
I know it's not a lawsuit, it's an inquiry.
so, with regard to what Superintendent Rio and Jelly and
Just excuse me, just so we can back up. Ms. Martin, what lawsuit are you referring to?
I just said, I think you were talking when I said it. I said, I know it's not a lawsuit. It's an inquiry. And I apologize. Thank you.
So when Superintendent Rio and Superintendent Jelly had applied for this money, did you recall reading on that themselves, reading in the application what they had applied for, what purpose?
They applied for funds for an SBHC.
Was that the only thing they applied for? The money?
No, they can't tell you exactly at this time, but there were other things contained within that.
And what amount was requested for, specifically for generation?
$4,000.
And after the board found out this was applied for without board's knowledge or approval, was there any investment they needed to have?
They left them in for that $4,000 placed elsewhere and the state was so right.
And the rest of that grant money, how was that used?
It was all used on staffing.
And what kind of staffing?
I believe whatever staffing we need to fulfill, we needed to fulfill at the time, and most of it being school psychologists and the area of mental health.
Did you subsequently have a proposal with regard to the behavioral health pilot program?
We did.
Okay, when did that appear? Did you propose about it?
So we thereafter, Mr. Angeli, Superintendent Angeli brought to us the information and the presentation of the behavioral health pilot program, and we adopted it like shortly thereafter, maybe within that meeting or the next meeting.
And what is that program about?
I believe that the basis around that program is to make sure that we have crisis intervention. So the children go and they see the school psychologist, or they go to the SBHC, but we want to make sure that the children that aren't able to do that, that are in crisis, that we have crisis policies and interventions in place through that program.
As a result of that grant, what did this word do in terms of staffing?
Not sure I understand.
Did you have a new position?
We created the position of, director of mental health and wellness. Yes.
And
And when was this created? What is the time period which you're referring to?
So the vote was taken in March, so I'm gonna say,
March of 2022?
so it had to be shortly thereafter that, maybe, May or June, but I'm not positive.
The pilot indicate that it wouldn't be institutionalized. Just kind of try this out. Be a pilot.
I'm not sure about that. I don't think that it's a trial thing. Yeah, that was trial.
Just wondering about the pilot.
Yeah, yeah, I understand what you're saying, but I don't think it was anything that was meant to be temporary or on a trial basis.
is that a program that was developed by the state board of ed?
I believe so.
State Department of Ed? Or did they offer that to you? Okay. And then you accept? Absolutely. And what things have been implemented since that time?
Other interventions that we created, we did add in, security resource officers. We had a lot of, feedback from the students that, with, kids are on their phone all day and they're seeing these school shootings and they weren't feeling safe in school. So we had been talking about, resource officers for quite some time, and we ultimately decided to, hire 5 of them. I did get feedback from the staff, and the security officers are amazing. They go out and they play at recess with the kids and they eat lunch with them, and they kind of become their friends and their mentors, as opposed to children being afraid of them being there. The children feel safer. So that's worked out really well.
And what is your favorite individual you created funding? Like we implement every other programs and intervention as a result of accepting the funding.
I believe that she has. I don't, off the top of my head, know exactly what those programs are. I know we have things like See Something, Say Something, Sandy Hook Promise. We have others, but I believe she can testify better to that.
Well, let me ask you some final questions here. Were there any temporary complaints made against the Board of Education before April 2022? And it's conveyed to you that the community found that you were being there?
Yes.
Were there any complaints filed after April 5th? That no, they're not. Were there any complaints filed by CSD against them?
No.
Was your staff and administration in relatively constant contact or communication with the State Department of Education before the vote?
Always.
It was in contact after the vote. Did the State Department of Education have an opportunity to correct things that you were doing wrong? Did they, your knowledge, indicate anything that you were doing wrong before the vote was for the vote? No. So the only complaint that was filed was the complaint filed immediately after you voted to reject your invasion. Is that correct?
Correct. I believe it was maybe within 3 weeks of our vote.
Okay. And the last question, is the board, was the board ever unable or unwilling to meet the educational interests of the favoring students?
Absolutely not.
And no further question.
McCann?
Ms. Martin?
You're not excused yet.
I'm I don't know how any of this works. She needed just to. All right.
We're gonna now ask if Attorney McKeon has any questions for you, and then Attorney Feinstein after that.
I didn't know we were getting cross-examined today. I thought it was today, and that's why I got a permit.
Thank you. Ms. Martin, as you know, my name is Michael McKeon. Legal Director of the State Department of Education. I'm going to have some questions for you following up on what Attorney Stevenson had asked you. You made reference to a survey in your testimony. Was that a reference to the CIRAC, the December 2021 CIRAC report?
Yes,
Okay. And I think you indicated that board members wanted to know the genesis of that report, in other words, how it all came about.
yes.
Do you recall when you first saw the actual December 2021 report?
I believe it was just prior to the board meeting where we were presented with benefits.
Here at the end of what you said, just right in the board meeting,
That we were presented with generations.
and I think that was January of 2022. And did you have any concerns about the responses that were in that report by students?
Yes, absolutely.
And what was the nature of your concern?
I mean, suicidal ideation is always a concern, whether it be one student or 20 students. So immediately I was concerned with that, especially because we had more children feeling unwell than ever.
And in fact, you were asked about board policy. Gonna go back to before, we can like pull back up. You were asked about board policy. There, 5141. I believe it was 51. Yeah, sorry, 5141.5, which is the suicide prevention and intervention policy. Do you recall being asked about that?
Yes, we did.
And it starts out by saying the Kimberly Board of Education recognizes that suicide is among the 3 leading causes of death among young people, and consequently is a concern to the school system and the community at large. Do you think do you think that's fair?
I do.
And don't worry, I'm not going to read the whole policy, but I'm only going to read one more sentence. It is the policy of the Board of Education to actively respond in any situation where a student verbally or behaviorally indicates the intent to attempt suicide or physical harm to himself or herself. And that's an accurate reflection of what your policy provides.
Yes, it is.
And you believe that that is in fact the board's charge to actively respond when indications of potential suicide arise?
It is.
And yet, the board really never in and of itself raised the CIRAC report, did it?
Never raised the report, meaning.
Well, isn't it true that it wasn't until a town resident raised it during the public comment section of the March 2022 meeting that the CIRAC report was even first discussed in a board meeting?
I'm not sure that there was really sufficient time between our vote and that coming up at public hearing for us to even get it to a meeting. But it would have always been addressed.
Well, you said that you believe you saw the CIRAC report, you by you, I don't mean just necessarily you alone, but rather members of the board, that you received a copy of that report prior to the January 2022 generation presentation, correct?
I believe that it was prior leadership who is no longer on the board that received that copy.
Would that be Janet Jones?
Yes,
And so you think that only Ms. Jolie was the only one who had a copy of it?
I believe that leadership was the only one that received any of that information prior to the board meeting.
I must have misunderstood what you just said, because I thought you said that you as board members, plural, received it prior to the January 2022 meeting. You're saying that's not the case.
I don't believe that that is the case.
So let me ask you again then, when did you become aware of your?
I became aware of this era, it's what it's been 2 years, so my memory is failing me a little, but it would have been shortly thereafter, after the vote.
Okay. And there were subsequent attempts to resurrect, so to speak, or reconsider the generations vote. Isn't that true? And you did not vote in favor of that, did you?
I did not. I wanted to accept the majority vote and move on to bigger and better things. I believe that everything happens for a reason, and I think that it did in this instance because we were able to find CHR. They're doing an amazing job. They're in 2 schools instead of 1. So I did. It's part of my leadership is to accept majority vote and move on to bigger and better things, and that's what we did.
Wow, bigger and better things. So you have a report which tells you that 14.7% of youth report having seriously considered attempting suicide, and 18.2% report having hurt themselves on purpose. But you want to go on the bigger and better things. That's your testimony? Okay. In fact, the CHR, excuse me, CHR agreement was signed on or about May 1st of 2023. Is that true?
Yes.
Okay. So that was approximately a year and a half later. After the generations presentation.
Yes.
Okay.
That had a lot to do with the 10-4 being filed and a lot to do with us releasing our prior attorneys because they were telling us at the time not to, they said, if you start speaking about further interventions or you start speaking about any of this in public, they advised us not to because they said we would be admitting guilt to the 10-4 complaint. We didn't like that all along. We ended up letting them go and hired Steve Stevenson so that we could pursue. But we were advised not to do so. That advice.
Now, it has been reported by the media that, in fact, it was on Channel 30 NBC, a report that at the March 16th, 2022 meeting,
Hearsay.
it's administrative hearing, hearsay is admissible.
Just finish the question.
Sure. It was reported on Channel 30 that at that March 16th, 2022 meeting, that's the one in which a member of the public raised CRF report results. The then board chair responded by saying, how do you know they were honest responses? We're dealing with kids. They could have written anything. That's what kids do. Do you recall Ms. Jolie saying that?
I do recall Miss Jolie saying that, and shortly thereafter, we asked her to step down because we didn't believe that that was fair.
And do you also
We
recall?
did a ruling on my objection.
Testify.
The objection is overruled. We can answer. You have answered.
And your vice chair at the time, now current chair, Roman Farren, did you recall him saying that he didn't think 14.7% was that big of a number?
Hearsay. He can call the attorney and he off the chair at the time.
I don't recall him saying that. Whether
So what happens is you're asked a question, there's an objection, just remain silent until we rule on the objection. Okay, thank you.
We are going to allow it. It is an inquiry. I think the latitude that we also gave to the students. And it's going to have means for questions.
I don't recall him saying that. He may or may not have it.
Okay, so received the CIRAC report sometime after the January 2022 generations presentation. On the March 16th, 2022 meeting, this becomes a matter of discussion. Somebody's raised the public comment. Did the board But is it true that the board nonetheless did not make the Sierra report part of its agenda of any subsequent meeting?
Don't recall if it was discussed in a presentation or not. We did not take big parts of a board meeting that I can remember.
Now, you say that student needs were being met at the time of the generations presentation, is that correct?
Yes.
And this belief did change once you saw this CREC report. Let's talk about 28% of you having had thoughts of hurting themselves. Over the mind that these needs are being met.
Saying,
Okay, so. Let me before that question, I'm sorry, let me phrase it a different way. You have a CREC report. Draw the line that student needs are being met. How do you reconcile what was in the CREC report with your belief that the needs are being met?
because the staff and the administration had always been addressing the issues from the very start. So of course, the CREC report is concerning, but nothing had changed that the staff was doing.
You read the October 24th, 2022 investigation report that I authored, correct? Okay, do you recall subsequently giving a radio interview where you claimed back to the report,
Say irrelevant.
just her comment?
You can ask her questions.
Well, I not object, and let me ask the question. Do you recall in the subsequent,
The objection.
do you recall in the subsequent radio interview with respect to the report claiming that I had lied through my teeth with respect?
That evidence, it's not, it has not been admitted. That report, this is what I mean, all the evidence has been decided for customers. You did not offer any evidence about
What's
that.
the nature of your objection? Your first objection was overruled. What's the nature of this
It's
objection?
irrelevant and it does not help to establish, it's not proven evidence fact that we can get to. It's a media report, it's an interview, it's hearsay, it's third party, and the witness is sitting right there. And that report itself is not admissible.
As I I'm asking what she stated. How did I do that?
I understand. Do you want to comment on the irrelevancy objection?
Well, it's a foundational question. I mean, Attorney Stevenson took quite a bit of time with this witness talking about what she claimed was in the case a year or 2 years ago. I'm essentially following up. And of course, that questioning tried to discredit the substance of the report. So I'm just kind of following up on that to approach further.
And we're going to allow it.
And what about the admissibility of that evidence to be asked upon?
That's
And reject
that's
the
why
admission of.
that's why we have witnesses. It's a long established practice.
To an exhibit not admitted.
Perhaps Attorney Stevenson should return to law school. Rule against hearsay is the admission of an out-of-court statement for the truth of that statement. In this case, Attorney McKeon is asking about a statement that was reported and asking whether it's true. It is of course admissible.
Asking questions about evidence not admitted yet.
Well, that's the whole purpose of interviewing, questioning witnesses is to elicit evidence.
May I, what's the nature of your, this is a third objection. Can you just repeat it so we can consider it?
1 would be hearsay, 2 would be relevance, 3 facts not in evidence.
As I understand, the question asks the witness if she made statements that were reported. So he's simply asking if she made the statements. Is that right?
Subjected to that being tried to in evidence.
Okay, it's the witness's own words. I would recommend that it be allowed. Witness is certainly permitted to speak upon her own.
And I'm fine with answering. I never gave an interview saying that you lied through your teeth. I believe that you are referring to a comment maybe that was made on a social media post. I never gave an interview saying Attorney McKeon lied through his teeth. So I would ask what interview that was.
Well, perhaps I'm misremembering, and I appreciate the clarification, but on social media, you said I was lying through my teeth.
I may have.
Okay, so, you indicated that reviewed the investigation report. You're aware, aren't you, that in that report, a significant part of it was predicated upon an affidavit given by your then assistant superintendent and current superintendent, Susan Nash Ditchell?
Yes.
So you don't think Ms. Ditchell was lying in her affidavit, do you? So, when Mitch is, minister doctor, I don't know.
She's a doctor.
Doctor, thank you, thank clarification. Dr. Nash Ditchell, when she stated that the CREC survey confirmed the district's conclusion that our students have increased mental health support needs, you would think that's true.
I would.
Okay. And when Ms. Ditchell, a doctor, I'm sorry, I apologize. That was totally inadvertent. And, hey. So when Dr. Nash Ditchell stated that as of May 3rd, 2022, Family School counseling staff had, quote, handled at least 660 unplanned or responsive counseling sessions, close quote, you think that is true?
Yes.
And when Dr. Nash Ditchell stated in her sworn affidavit that as a result, Family was required during the 2021-2022 school year to implement a kind of counseling triage involving counseling priority forms, you would agree that that was true.
I would.
And Dr. Nash Ditchell gave a sworn affidavit that visits to school nurses, quote, increased from a total of 3,069 visits during the 2020-2021 school year to 3,581 to April 26 of the 2021-2022 school year. That would be true.
Yes.
So, despite that, you believe that everything was going okay, telling the public schools with respect to student mental health needs?
No, I never said everything was going okay. I said that we were never unwilling to address the increase.
I have a question, Ms. Martin, I don't mean to interrupt, but the report of the survey was December 2021, correct? And it came to the board, the following board meeting. Now, you stated that you didn't see that survey, that only the previous.
I don't think it came to us the following board meeting.
That's what you said, it came in January 2022.
Not in the board meeting.
Okay, but then it was first raised in March of 2022 by public comment. And then you went to say that you were advised by counsel not to publicly comment on any health services. What did the board do between this whole span of time? That was around March 2022, and it was almost a year later before any contract was signed. So what occurred at that length of time?
Well, the 10-4B was filed in April, I believe. The vote was taken in March. The 10-4B was filed in April, and that's when our attorneys were advising us to do nothing.
So from April until the following May, what occurred? That was April 2022,
Yes.
and you signed with CH.
Yeah, we were doing the research. We had to create the ad hoc committee. We had to get to meetings. We had to do interviews with the other organizations. We had to get it to the full board. That takes some time.
Okay, thank you.
Ms. Martin, you had testified in response to Attorney Stevens' question about your taking back from the superintendent the authority to seek grants. Is that correct? Okay. And was that as a result of the request for ESSER 2 and or ESSER funds that Mr. Angeli had submitted to the state? Okay. So did you? So you were not aware of the substance of what he had put in those requests? Or
We were not
applications?
previous to no.
Okay. And did you disagree with what he had put in there?
And I disagree with it. No, I voted yes.
So when he said there is an unprecedented level of stress on both students and staff members, and that's on April 16th, 2021, you agree to that?
I did.
Uh, And one focus area should be on additional behavioral and mental health services. You were agreeing with that.
I was.
So, then why with that, and why then, if you were in agreement with that, why then did it lead to the board saying, well, we're gonna reclaim that power, or for lack of a better word, that the superintendent had with respect to requesting grant?
I think I explained that if a board is going to be held responsible at an inquiry for a grant, you should know what's in that grant prior to it being approved.
And that's understandable, but in this case, you said you agreed with what former Superintendent Angeli was saying about the need for mental health support, correct?
I did.
And you recall that in some of those grant applications, grant plans, however you want to phrase them, that former Superintendent Angeli also made reference to the connection between chronic absenteeism and the need for emotional support.
I did.
And did you agree with that?
I did.
So so then it would be fair to assume that you agree that mental health services are directly related to attendance.
Yes, and we recently hired a new attendance coordinator who is doing an amazing job. She's following the LEAP program, making home visits, and our attendance has increased exponentially. It's almost 22% as of the last few months.
When did you start with the LEAD program in Gillen?
The LEAP program was just presented to the board a few months ago, so I don't have an exact date on it. It was this year. It was, yes. Thank you. I believe so.
And you made reference to the ad hoc committee. You were the chair of that committee.
It was.
That was formed until after the state boards of November 2nd, 2022 vote, correct?
Don't have the exact date in my head, but if you tell me that,
Well, I'm not telling you to ask them.
I don't know the date.
Okay. Stevenson asked whether I had ever gone willingly and speak with the staff members. Do you recall her asking that?
I do.
Do you recall on August 26th of 2022, coming down with Mr. Ferris and Dr. Nat Bitchell, Mr. Angeli, at the CSD?
I do.
And Mr. Stevenson would be very happy, correct?
After much of a fight, she was allowed to attend.
I don't think there was anybody whatsoever.
It took quite a while for you to agree to let us have our attorney there, and we also denied a steno,
All the time, but
a stenographer.
you know you're testifying under oath, don't you?
I do.
You know that's not true with you. That's what
That is absolutely true. 100%, and I believe that we have it in writing. I mean,
Are you aware of the fact that Killingly staff members had been told that they would be disciplined if they spoke with you?
that they would be disciplined if they spoke to you.
Yes.
I'm not aware of that.
You made statements that you spent a lot of time trying to schedule a mediation. What do you think that?
My discussions with attorney students and
Are you exactly aware of the fact that scheduling a mediation was something that was discussed?
was never something that was discussed. I believe that it was discussed in an email that we should have some sort of mediation. If it's not, it should have been.
Attorney McCann, really quickly, can you clarify, or maybe, Mark, if if it was said that the staff would be disciplined if they spoke to you or spoke with you? What is it? Speaking to him and saying hello. Oh, okay, right. Clear distinction.
I'm saying with me.
Thank you. Thank you.
I believe the intention of that was to not speak about the 10-point.
Got it. Thank you.
For the staff not to speak about the 10-point party?
With Attorney McKeon. Right. Because we had representation.
You testified that you felt that in this question, it's in no way intended as a criticism of your staff. But I believe you testified to the fact that staff was never falling behind on students. But that I was asking you before, Dr. Nash Jitzel had indicated in her affidavit that they had to establish a counseling triage at some students. Correct. And is your understanding, or do you have an understanding as to the fact that job description for school counselors does not typically involve giving the school counselors, it's involved giving direct counseling, emotional counseling services to students? Okay. So, on May 1st, I believe it was May 1st. I know we have an unsigned copy here, but I believe it was around May 1st this year. Killingly and CHR, and the wrong agency here. That CHR executed the memorandum of agreement. And you indicated that that provides for CHRO in Killingly Intermediate School and Killingly High School, correct? So how many days a week is CHR in high school?
I believe they started out at a half a day. The need increased. They went up to a day and the need increased again, and they are now going to be there.
Okay. How about the intermediate school?
I believe it's the same. The numbers are the same. And I have to have the superintendent or the mental health director give you a clarification on that, but I believe it's the same.
That's fair. So is it then, so it's not the same staff rotating between the two schools, they have two separate groups for individual what have you.
Correct.
And is there a process by which students can refer themselves to see the CHR staff members?
Yes, I believe they go to the principal or school counselor. And request.
And this is, to the best of your knowledge, I don't want to, assume anything, but is CHR, is that funded through insurance? In other words, I'm going to see them and then they charge parent health insurance? Okay. So do you have an understanding as to what happens if a student that family doesn't have health insurance? Do they still go to CHR?
I believe it's based on the sliding fee scale. Yeah, I can find that also.
That's fine, I can ask. Thank you.
Attorney McKeon, we're around the time to break for lunch. I don't know how much longer. I don't want to. Okay.
I'm trying to be sick. I don't always succeed.
Take your time.
I want Martin to be up there any longer than she has, but it's. What is the difference between, from your perspective, what is the difference between generations at CHR?
I think the only real difference, they're very, very similar. The only real difference was reviews, online reviews. State jobs were much better than generations. And I believe that the other difference would have been the parental opt-in.
I'm sorry, the what?
Parental opt-in.
Thank you.
What exactly do you mean by that? Department of Law?
Well, if a child chooses to get the services through CHR, the parent is notified and the parent would fill out the paperwork and sign something saying, yes, we agree to this.
Okay, so what happens if you have a student who would prefer to be there, to have some emotional concern? They prefer not to share that with the parent. How would that work then?
Yeah, I mean, that's concerning. We're very concerned about that also, but that student would be able to go to the school counselor. There's no parental opt-in to see a school counselor, and CHR is there to take the load off of the school counselor, so the school counselor would be able to meet and with that student, and if they thought that there was a crisis or a problem, they would call 211, they would call DCYF. They would do what they had to do to take care of whatever may be happening with that parent.
The therapists who are working for CHR, are they the ones who are actually in school? You know, are they psychiatrists? Are they psychologists? You know?
They're psychologists, fully licensed.
And you indicated before with respect to your own staffing, that you're fully staffed in for school psychologists, correct?
Correct.
Would it be fair to say then that you're not aware that the Family Public Schools website is currently advertising for a school psychologist at the high school?
If it's there, it may be old, if not, I'm not sure, we have to ask, superintendent.
Could you define for us fully staffed? What does that mean?
In the counseling department.
How many people? When you say fully staffed, is it
Fully
one
staffed,
counselor
well-
each school? Is it 3 counselors each school?
I believe it's a total of, well, the district. And we did have a lot of openings. Pretty post-COVID, and they've all been filled. And that's what I mean by fully staffed. They've all now been filled, those positions.
I have a couple more questions. I just want to ask about the East Con contract that Family Board typically do, like in July this year. Recall how that came about? Yes. Were you in, well, is that something that would come through the ad hoc committee?
No, that was something that I'm gonna assume was done through administration.
You call it the board vote on that?
These time?
Yeah.
We did not.
Is the ad hoc committee still in place or was that?
No, we just not, yeah.
It's the HR.
At least HR.
I have nothing further to say.
Before we break for lunch, Ms. Martin, EastCon contract expires in June 2024. That can be renewed.
They can, yeah.
Do you know where that stands now with the board?
I do not, we'd have to ask the administration because we did not. There are still a lot of things that the administration without us because they handle the day-to-days and they know that some of this stuff is important. And they're allowed to do that without us. So the EastCon contract went through administration, not the board. Can't really answer any questions on that.
Okay. Thank you, Ms. Martin. We're going to break for lunch. We will return at 1:15. Attorney Feinstein will be able to ask questions. Adjourn till 1:15. That's me.
Well, we could leave it. I just want,
It's okay.
I know.
Oh,
Before you get done. If somebody's ready for an open.
And the gavel.
Yeah, I know. Interesting.
Okay, we're back to resume the Killingly inquiry. Its time is 1:23. Attorney Feinstein.
I was. Want to go over the chronology at the beginning of. Yes, Attorney Jim. Want to go over the chronology. When did you enter the board?
December of 21.
Okay, so the election that took place in 21, you elected and entered the board at the first board meeting in December of that year, correct? It was the first time you heard anything about the generations contract.
I'm going to have to say, it was. Vote was taken in March, so it was right, it hadn't been done in March. Leadership then, so I wasn't aware of what was going on. But it only came to the board.
You talked about a information meeting held in January, correct?
January.
No? What was the information meeting?
The informational meeting with generations.
Yeah.
Would have been, I don't know if anybody else has the answer on that, I don't have an exact date.
Were
Mr.
you,
Barron?
you're the witness. If you don't know, you don't know.
Apologize, I don't know.
Were you in attendance at that meeting?
At the informational meeting, is it what?
So you certainly know about generations at that point.
I did.
What happened at that informational meeting?
Basically, they just came forth and gave us a presentation on what they would provide our schools if we were to agree to contract with them.
And did anybody in the audience raise any concerns about what they presented?
At that meeting? I don't remember. We have so much public comment, I don't remember.
Okay. And then the next event was the meeting in March where the vote occurred, right? What do you remember about the discussion of that meeting?
Not sure what you're asking me about the discussion during the meeting. I remember having discussion on why yes, why no. It's hard for me to remember exactly. I do remember we had a discussion on how people felt about generations. And then we took the vote, but it was very short.
And there was public comment first, right?
It was,
And the comment was overwhelmingly in support of the school benefits.
I believe so, yes.
Now, there've been, if I listen carefully enough, there've been three concerns about the generations contract. Right? One is the issue of parental consent. The second is there were no options given. And the third is that the social media reviews of generations were not good. Is that correct? Were any of those issues raised at that meeting?
I don't recall if they were or they weren't. A long ago.
And you said you had no knowledge of the mental health crisis until that meeting?
I said that personally and I acknowledge that it was exacerbated post-COVID.
Okay.
Nobody was administration prior to that. Yeah.
Now, you testified about the discovery contract. You were not on the board when that ended too.
I was not.
You were not on the board when that ended, correct?
Right.
Is it correct that it ended March of 2021?
I don't know, I just know it was during COVID. So it's when the kids weren't in school, I came to.
Friday, March 13th, 2021 was the last day of school before the 12th. Now, since you become aware of where it's become more aware of this crisis, we've added one new position, which is Kathleen Cody's student, right?
I mean, it was in that area, administration.
Okay, within administration, have you increased the complement of school psychologists in early schools since then? Yes. What psychologists are there?
Two. And it used to be one.
Right. Isn't it the case that schools spend most of their time asking for special education?
I believe so.
In other words, they do not provide a great deal of counseling, is that right?
If they do what they have to do.
Has there been an increase in the number of school counselor positions?
School counselor positions. So that was, you previously asking about school psychologists, the school counselor positions. I don't believe there's been an increase,
How about school social work?
same.
Are there any other mental health positions in school, only school?
Okay.
And moving on beyond the March vote. Isn't it the case that the ad hoc committee did not meet until November 30th?
I believe so.
What steps, if any, did the board take between March meeting, November 30th, to deal with what you characterize as a mental health crisis in Killeen?
Between the time of the vote and the November meeting, we were meeting behind the scenes discussing what we wanted to do, looking at researching companies and organizations that we could meet with, and also scheduling meetings, having subcommittee meetings, and we were also told not to do anything. So it was put off for a little bit at the advice of our attorneys.
It's hard to believe, but it's your testimony that the lawyers at Fitman go and told you to take no steps to deal with what you knew was a mental health crisis for a period of 8 months.
They did have it in writing. They did tell us that. They told us we would be admitting guilt with that advice.
And you have it in writing.
Have it in writing.
I'm going to ask if that could be made an exhibit on. There was a meeting that Dale Dauphiné held at his house.
I'm sorry, I didn't get the name.
Dale Dauphiné. In June, late June of 2022.
Objection.
Just let him finish the question.
You were in attendance at that meeting?
No. I have an objection.
Yeah, if you could just wait to enter your objection till after he's done with the question.
Oh, that was a different one.
My point is just so we can have to confer with the chair, we can decide on the objection. So you want to ask the question again, Andy, and then.
Okay, with that, were you aware of such a meeting?
I don't believe so, no.
No. A meeting about school and health.
I did not attend.
1 second.
You did not know about it.
1 second. There's an objection. What's the nature of your objection?
Are you talking about the evidence you have proposed to get about the animal thing?
And talking about whether there was a meeting about school-based health centers in Kelly Lake during the summer of 2022. I was asking whether she knew anything about it. You said you did not.
What's the objection?
Well, first of all, he's changed the question several times. The original objection was to some sort of meeting with them. I don't know what that means.
What are the grounds? What's that objection?
Overall,
During that period, March. Was the issue of school-based health center.
Mr. Feinstein, Attorney Feinstein, I'm sorry to interrupt. Who is Dale Darvin?
He lists himself as the head of the choir team. Little bit, we've got more on that later. Right. During that period of time, March 22 to the morning, correct?
Yes.
Did the issue of school-based health centers come up again at those meetings?
Only to try to put it back on, I think that's the only time they ever were discussed, it's the original not, so.
Is it not the case that there were people who wanted to make public comments and were not allowed to during that period of time?
That is not the case.
It's not the case.
All the public comment rules were followed.
Can I ask a question again? Because I'm not sure if I heard you correctly. I think you asked what meetings took place. There was no board meetings between March and November?
No, she said there were meetings.
So there were meetings. Okay.
Sorry, except during the summertime.
I thought you said there were none.
I apologize that she's facing away from
Okay.
me. She asked that so we can look at each other. So anybody who wanted to comment on school-based health center during those public meetings, put it on something.
Within the time period that we put a lot of things.
I want to explore the situation with CHC. How did CHC come to your attention?
Through anything.
That, the minority leader of the Medicaid legislature.
Correct.
Were you directly in contact with Mr. Kindler, or did you use your local representatives to do that?
I use my own representatives.
And that's in Dauphin. Was that her only role? Was she involved in this process?
She was not involved at all. That was her only role, was to put me in touch with him. He's got to touch with him.
Okay, now what was the ad hoc committee appointed?
So many dates in my head, I'm forgetting. Shortly after the fall.
Like March, April.
Eventually,
Okay, and you were chair during that period.
I was chair of that.
Didn't tell the reasons.
So I resigned, correct. I resigned after the sabotage, so to speak.
We'll talk about that. So you had an initial conversation with CHR, right? CHC.
Yes. That's it.
And who else was with you when you had that conversation?
The CHC, so that would have been myself, Mr. Farron. I believe there's two other board members.
Were there any Democratic board members in that initial call?
No.
Why was that?
Because I was bringing it to the ad hoc committee to bring to the Democratic members. I think that would be an illegal meeting. So I do know we did not have a quorum. I asked a couple of board members to come in to help me retain some of the information and give their advice. Nothing was done malicious, like, we just wanted to get information to bring to the ad hoc committee.
Okay. That was Sue Lynn was a member of the ad hoc committee, right?
She was, yes.
And she wrote an email to CHC on December 1st, correct?
Correct.
You get a copy of that email?
When CHC sent it to me, Chris Land never sent it to me, CHC sent it to me to make me aware that she was asking them questions outside of the meeting. Yeah.
Okay. You would ask questions of CHC outside of.
I did ask the chair. It's my responsibility to bring information to the committee.
It's okay for you to ask questions outside the format of the committee.
Yes, because it was previous to me bringing them. I had to get the information to bring to the committee. As the chair.
There were four members of the four Republican members of the Board of Education who were in on that meeting. And so you're aware that Ms. Lannon wrote an email on December 1st.
Yes.
I assume you have interviewed.
Grab my glasses. So that your exhibits are not numbered?
They are. Bottom corner when the first page we just done. I-10.
What you're saying. Yes, no.
I-10.
Okay, got it.
You've seen this document before?
Yes, I have.
And it was your testimony that was given to you by the event Francis of CAC. Okay. Now,
Or Jane Highland, one of them.
okay. Refer to I-11. And have you seen this document before?
I have.
Now, this, she talks about, was going to meet the ad hoc committee last night. All right, in the first one.
I say yes.
Did he formally meet on November 30th?
Subcommittee, the ad hoc subcommittee?
Not everybody.
We did, yes.
So this was likely written on December 1st, is that accurate?
Correct. Yeah.
And also the same day that Sue landed Centurion, correct?
Yes.
Take a moment to look at this and tell me whether there's anything that you disagree with in what Ms. Francis says here.
Okay. Yeah, anything disturbing?
Other than this December 1st email, Stu Lannon to CHC, are you aware of any other emails she sent to CHC?
Trying to go down in my head and try to get accurate information. They don't know. How is it?
But she then had correspondence with you, right? And if you turn to I-12. This is her email to you and your response, correct? Okay. And does she say anywhere in her email that CHC is unacceptable to her?
Says CHCI seemed far more obligated in accommodating the political directives of the Killingley Board of Education majority than addressing the needs of the students of Killingley. So I would take that as they're unacceptable. Yeah.
Okay, you assume that means it was unacceptable.
Right.
But she never said it was unacceptable, did you?
She said it was too little, too late. And she did an article, an interview with the Norwich Bulletin, and she said it was too little, too late, so that means unacceptable to me.
Okay, you're entitled to leave to that conclusion if you like. There was never a vote on that issue. Right?
On the CHC, they never got that far.
CHC dropped out because CHC declared their lack of interest in participating in early January, correct?
Yeah, we didn't need to see it until after the vote in March.
Well, we're talking about the CHC.
We're in the following year.
Yeah, sorry.
Anyway, my dates are all over the place.
Yeah, could you repeat with the correct years and those
Yeah.
questions, please?
Well, so the ad hoc committee first met November 30th, 2022. The correspondence between Sue Lannon and CHC was December 1st, 2022.
Correct.
The correspondence between you and Sue Lannon was December 3, 2022.
Correct.
CHC announced they were no longer interested in participating sometime in early January of 2023, correct?
And yes, no.
And so on what basis are you saying that Sue Lannon's emails and public comments caused CHC to drop out?
I'm not saying she was the sole cause. I'm certainly not. I'm saying it started here and it continued on with community members, some of the concerned parents, yourself, Sue, on the local radio station, in the news, and it continued throughout this whole month into January. So it was a culmination of all of it, not just this land. So I never blamed her solely. She started.
Well, except the board voted to censure her. Correct.
Absolutely, because you're breaking rules and policies, and that's what happens when you do that.
We don't need to go into that, but that's, disagree on that issue. Now, you said that I said something. Where do you see that I had made any quotes during December 2022 about CHC?
I see that when you were reposting things on Winnie, everything that was done throughout this whole hearing, you posted onto Winnie. And I think there was one press release that you put out saying something to the effect that it was too little too late.
Well, I don't want to testify here, but I don't post. I don't do social media.
No, you're posting on the Winnie local radio station. Numerous press releases from you on the local radio station. And one of those was calling out, and one of those press releases was calling out CHC as to being too little too late.
Only statement I issued was after CHC dropped out.
Correct. Not the only statement.
The only thing that was posted at all was after.
Yeah. But you've been posting on with the local radio station since the beginning.
Well, I would ask you to present evidence of any posting with my name on the Winnie Facebook page during December 2022.
I can bring them all with me.
Can we move on, please?
Like,
Can we move on, please?
Okay.
Okay.
So you were at that recent board meeting where Kathleen Cote and Pepper talked about what would be done with health services. Correct? You remember what she said about limitations of what school mental health professionals can do as opposed to what a private counselor can do?
I don't remember.
Testimony on that. One thing she said in there, and they just sort of alluded to in your testimony, was that parents and students are going to be able to self-refer to the HR. No letters going out to parents yet. Right.
I don't know, you'll have to ask the administration, I know that are here, we sat down, we reviewed it with them, and it was supposed to go out, I don't know the exact date, so you'll have to ask them if it out.
Does CHR have the capacity to deal with self-referrals at this point?
Do they have the capacity, meaning, enough counselors to treat? Yes,
They do.
yes.
How many counselors do they have?
We have one right now, they're, hiring somebody to add to their third day. They're in the process of hiring somebody to add the coming on third day. I believe, I don't want you to quote me on that, but I know they're in the process of hiring.
They initially said that they would staff up based on whether they determined the need.
Correct.
How can they determine the need if there's not a chance for people to the self-refer and compare with referable students?
There's a chance.
Is there now?
No, they go to, school administration, or administration would take it from there.
And that, has that been communicated to parents and the students?
I believe so.
And it's,
No, I don't know how, I don't know if they're by email, by mail, I'm not sure.
well, if you can find some writing that says that. I appreciate that.
One of the administration here might even have that,
And you know the date that went out?
you know.
Now you, testified that, Attorney McKeon, did not communicate with the staff. In his investigation.
Oh, they were at an initial meeting, correct?
Thanks. I know you're aware of this, email from, Superintendent Angeli, December 9, 2022, telling staff not to talk.
I believe, yes.
And so the fact that he didn't talk to staff, not surprising, correct?
After that time, yes.
And did,
But he could have done it through our attorney. The reason for that was because we were represented. We didn't want anybody talking without going through the attorney. So he could have, through Attorney Stevenson, had plenty of talk.
with her present,
With who present.
with Attorney Stevenson present,
Absolutely.
meaning that, employees first about their job future, who might have something negative to say about the public schools, would not be able to talk, correct?
I don't believe that to be the truth, but that's the way you're hearing it.
Well, was there any protection against retaliation for employees who might have talked?
We have no retaliation against them, nor would we want to retaliate against them.
This, email to staff on communication, was that something that the board, that Mr. Angeli put out?
It was suggested by our attorney to the chair.
Just to clarify that, so the chair issued for the email to go out via the superintendent.
Now, you said that there are no new counselor positions, but you have hired 5 new security personnel for the schools?
Yes.
These are not school, these are not school resource officers.
Their own security resources. So what do you call them? ASOs. Security
They're
officers.
not, you know, badged police officers, right?
They're retired.
Are they armed?
And,
And what are the backgrounds of these retired police, prison guards, some of them?
retired police officers, I don't think there's any retired prison guards because they have to have the qualifications of an officer.
There was legislation proposed to expand the scope of that. Has to be repetitive.
Yeah, we don't have any retired,
Talk about bringing Rachel's promise in. Was that seen as a mental health issue?
No, Rachel's challenge was being, looked into us well before the 10-4B. We were looking into it. We thought it was a good initiative, for voting.
Okay, so are you suggesting that it's something that the Killing League Board has done to promote mental health among students or not?
Well, I think, when you're not being bullied or the bullies are taking apart what can happen, I think that certainly goes towards the mental health of the children that are being bullied. But it wasn't an initiative that we put out for this.
Let's talk about parental consent a bit. Exactly what is the difference between what Generations offered on parental consent, what is CHR is offering?
CHR has a parental opt-in, so the parent would get notified and they would have to sign something saying, yes, I approve of my child being treated. Whereas Generations.
Did you ask Generations about that?
We did.
You did.
We did.
That's a requirement of all school-based health centers. And so, and they comply with the rules of all school-based health centers.
So BHR has always had this informed consent as part of their practice. Generations did. So CHR is just giving us exactly what they've always done.
Our different Generations didn't have that. They told you that, when?
Meetings.
Well, you said you had one meeting with them, the information session. And you asked
And
them,
we have the informational community meeting with them. We asked at that meeting also, or some of the audience asked at that meeting if they're gonna have a function set.
the implementation plan, that Generations put out included that, did it not?
Included what?
Parental consent. Okay, well, put that to me later. That's accurate.
Sure.
And there's one exception to that, right? Treatment of teenagers who are competent without parental consent or knowledge. That's state law, correct?
Correct.
And CHR and Generations both follow the same policy on it, correct? And any student can go to a mental health professional in school and say anything they want without any parental consent, correct? And very tempted to ask you about that Children's Health Defense podcast that you did. But I think the chairwoman would not appreciate my spending time having you repeat your attacks on me. And
During that, continue my attacks on you.
yes, ma'am. But I will, so I will.
Right. I think the video was an exhibit.
Good. We can talk about that in another context. We're not waste time and attention. See if I cross examination. It's point that you.
Do any of you have any redirect ID with Kelly Martin?
I mean, Martin, with regard to Attorney McKean's questions. Here, you were asked about the CREC survey and whether you considered that again after Virginia. And the survey was a moment in time. It was a survey of people. The results of that survey, in terms of meeting the needs of children, discussed after that, not the survey itself, but
Yes, not at board meetings, but with administration.
yeah, and it's true that you delegate, you as a board delegate responsibility to the committee staff and the administration to meet the needs of the children. On a daily basis, yes. And when the reports back to you that there were any problems with meeting those needs from your staff administration, now, other than they I would assume from HR or whoever, trying to fill open that were, really open for staff. And was there any time where you asked the staff to stop recruiting for any staff? Ever? So this was an ongoing matter, you kept searching for staff. Yes. And isn't it true that the positions, some of the positions you were trying to fill were not just shortages or unique to Florida, but there were shortages of these kind of positions throughout the state? Well, did that occur, did that appear on the state websites at all? It did, and that's where okay, and what did you find?
I found notifications on their website that this is something that is occurring all around the state. It's not just a California thing.
And what kind of staff people are we talking about that there are shortages?
Mostly counseling.
And psychologists including psychologists. And at this time, before the vote and after the vote, you were actively recruiting for those positions. And in your testimony today, those positions have been filled that were open and positions were fighting. Yes, they have, including psychologists. And psychologists remain shortage across the state at the moment, right? Correct. But you were looking up to find psychologists again. Sure. The districts have been so lucky it's correct. Now, during that time, it was a time period where there was some question about you weren't doing anything to find interventions. Was that actually true that no, the children were not being given interventions for their mental health? Never. So that was continuing assessing students for needs. What is your policy once you know that they did after they identified some of the needs?
They were always sent to a school counselor, whether that be through overtime or during school hours. They were referred out for outplacement. They were always addressed.
And there was some testimony about perhaps not getting the right treatment or interventions immediately, and because of the triage system. Is that something that is uncommon?
I don't understand that question.
Okay, let me rephrase it. If Killing had a triage system because there were students CDs and they were actively trying to help those students, was it reasonable for them to have identified students in order of their needs?
Yes.
Objection, that there's no foundation established that would let us know that this would just that qualifies to talk about practice or challenge follow the school counselor on this.
I think she has active intervention communication with the school superintendent and with staff with regard to these kind of interventions and help if students. I mean, that was the whole point of this whole discussion after the CIRAC survey and the vote, et cetera, of how these students are in need and what is being provided and how we service them. It's the request for trying to find other staff. So is that something that you would have discussed with your superintendent?
Are you withdrawing your question? You're asking another question?
I'm trying to explain that.
That's an objection pending. Can you read that question?
There was some testimony about perhaps not getting the right treatment or interventions immediately because of the triage system. If that's something that is uncommon. Oh, wait a minute. Hold on, I got one question. All right. Let me rephrase it. If Killingly had a triage system because there were students in need and they were actively trying to help those students, was it reasonable for them to have identified students in order of their need? The answer was yes, it was. Yes, that was. And Mr. McKeon had an objection.
The objection is sustained.
Was there any time that you were aware that students went unmet? Ever? Even though there was an increase in counseling, and 600 counseling sessions that Attorney Peter referred to. Did staff ever tell you that, oh, we couldn't meet any of those needs?
Never, they never once said they couldn't meet the needs, and we never received a complaint.
Ms. Martin, how often would the staff address the Board of Education about the needs of a particular school or?
They
Is that a
do,
common practice in Kelly?
it's common that they come to board meetings and discuss these things with us, and leadership generally meet them behind us to discuss these things.
When you making reference to leadership, who are you making reference to?
The chair and the vice chair.
Of the board?
If there were a need, if your staff and the administration had a need, would they come to the board to request additional budget for that?
I believe I would, yes.
And did they ask for anything out of the norm? With regard to the ESSER and the ESSER funding, again, the rest of other than the $4,000 for generations, the rest of that money went to staffing and then what kind of fiscal psychologists and basically that general area. Okay, and that part, ESSER and the ESSER grants, especially the ESSER grant, was about what year was that? Well, was it about the same time as they were asked for the relations, like all before, but those are the can't remember, I don't know. So you were asking for additional funding for staffing for mental health needs, yeah, at that time before the open generation. And you received that grant, right? And then you used that grant to help with your staff, directly mental health needs, yes. So with regard to CHC, and there was some questioning about the timing of, well, you didn't or try to adopt or do anything about CHC until late year, there's some months that went by. Could you explain for us again what happened with that time frame and why you were not able to do anything with CHC until that time? You were advised not and advised by plaintiff's attorneys. And then what happened after that? What made you start looking into alternatives disregarding that?
Well, our attorneys are saying, common application has 20 days to get this report out. So the most you're gonna have to wait is 20 days. We waited 6 months. At that point, we were pretty positive that we had to go forward. We could no longer wait, so
it took, instead of the investigative report being completed in 20 days, you're saying Attorney McKean in another 6 months to finish the report in some cases. And it was during that time that you had been advised, wait until the investigation report is concluded.
correct, wait until the report is concluded. So we waited and we waited and we waited and we waited and until we could no longer wait. That's not something we can wait on.
And did you start looking into alternatives before the investigation report came out at all?
Yes, we did.
And approximately how many months before that investigation report came out?
So it came out in November, so I'm sure. March. I'm thinking we were already looking into alternatives shortly after the March meeting. I can't give specific dates, but it was very close thereafter.
But you didn't do anything formally about the season back on committee until.
Until the report came out, correct?
And then, was the board required by law to adopt a school-based health center?
No, not that. We're told.
So, if you were not required to adopt a school-based health center at all, could you reject generations for any reason you wanted to? That one, you could. But yeah, you had the informational sessions, you studied the issue as best you could at that time before making your decision. And then you continued your investigation and consideration about other school-based health centers. But with the vote all about the mass meetings and it's. There was some talk about, attorney making, not coming to everybody or met with him. He asked me, you met with him. Where did you meet with him? We met with him here. So did he ever go down to Killingly to have eyes on Killingly, the students or the staff or the classroom or anything ever? And there was some questions about the communication that the board chair had put out to staff saying not to communicate with state board of education. Can you provide a little more detail about how that came about and why?
I believe it was because discussions were happening between the previous superintendent, Mr. Angeli, and Mr. McCann without our knowledge. And we decided that that was not acceptable.
And why was that?
And it's not acceptable because we have an attorney represent us and everything should go through you.
And was that limited to the technical review complaint? It is that we were not able, he was not able to discuss or his state farming litigation.
I'm sorry, if you could explain that a little better.
Okay.
What was it to?
Okay. The for the staff, including superintendent and required by that directive from the board chair, to be completely silent and have no communication at all with the Department of Education.
No, absolutely not.
And then how did the communication occur from that point forward?
They would just send us an email staff saying we need to speak with the Department of Education about such and such. Is it fine to send this email? And we would approve it.
And those were emails that were not in relation to the 10-12 complaint. Right. So anything other than the 10-12 complaint, they were free to discuss with the state Department of Education.
Yes, always.
As long as the board was made aware that they're going to do that. Right. So you were not trying to limit the communication at all in terms of day-to-day business or grants or helping the students or anything like that, right? Right. With regard to the concerns about whether the students could go to get counseling and such referrals, could the students go to a counselor and discuss, with their parental permission, say under CH? So the parent has notified the person in the forum, and then the student gets some counseling. At that point, if the student says, I don't want my parents to know about counseling, would that be allowed?
If they had already been treating with them?
Yes. Yes. So you would be following the law in that regard, correct? Correct. So but there was a concern at first that the parents would know. Now, with regard to Attorney Feinstein's question.
You said yes to the question. Yeah, I think you.
I said yes. I'm sorry, I nodded. I didn't mean to say yes.
It's repetitive, so I'm not going to really. You mentioned that there was some concern that Attorney Feinstein's comments affected the ability of CHC to go forward. And about one month, what kind of year was that?
Those comments surveyed,
Yeah,
it would have been right after we wrapped up. He did attend, I think once he did attend the committee meeting with CHC. He did express that he thought it was a great option for us. And then it was days after that that it stopped happening. What's the pushback? CHC on the motivators.
from attorney mindset. And so if you believe those comments on the local radio station were contributing factors to whether the HC focus. So is it safe to say then that you had a school-based health center in place long before being dark? You would have. About what time period would that have been?
So we met with CHC and that would have been
December 2020. December 2022. That would have been when you would have been able to sign a contract with CHC?
yes.
And instead, you had to look for other alternatives. And then did you find CHR and were able to sign that contract?
After doing our engineering, we were ultimately able to sign in May. Great.
So, several months then, in December and May, you would have these health centers. That's correct. And we're not for the implementation. That is correct. In part on 3 months. And the the armed security personnel that you said you had hired to be fired. That represents that. Who pays for that for the staffing of the armed security officer? Right. And is that in cooperation with the town at all?
Yes, it is.
So is that money split or how does that work?
I know the town does the hiring as they control the constable service. So the town does all the hiring and the board pays for it. Yeah.
So if you didn't have any pushback, get any pushback from the town?
No, they had to take a vote after we voted on it and they voted unanimous, yeah. No, not unanimous. I think it was 1 no. The rest was yes.
And have you had any problems with the armed security officer?
We have not, it's been amazing, absolutely amazing.
So you would say that goes in part to providing safety to clients, correct? That's always good.
Attorney McCann?
Yes, I had some questions. Thank you. Before you indicated that there were discussions with this administration about the CRX survey. Do you recall testifying to that?
Yes.
And what was the nature of those meetings?
Those meetings, I believe I had said were with the previous leadership.
Leadership of the district or the board? So that would be you and Darren?
No, I wasn't on leadership.
Do you know who participated with them from the
We missed Jolly.
I'm sorry, from the administration side?
I would assume that it was Superintendent Angeli.
Well, just testifying that the chair and vice chair of the board would be the staff behind closed doors, discuss issues. The issues being the concern about student mental health support. Is you part of those meetings?
Not long.
And Were these posted meetings pursuant to the Freedom of Information Act?
I know we have meetings, prior to board meetings with our superintendent.
And so when you say you're meeting with staff, you're both board to your superintendent?
Correct.
Okay, they're not actually staff members of the school.
Correct.
Now, you stated that the attorney, Stevenson asked you again about whether or not I went to Killing Place. You indicated that there were communications between Mr. Angeli and me. What were these purported communications that you were referring to?
He told me.
Oh, yeah, well, what communications did he apparently tell you that he and I had?
I might have one or two emails indicating that he had had conversations with you, but for the most part, we had telephone calls or you.
But when were these alleged communications? That's what I'm trying to ask.
They were shortly after your report. Or maybe in between. I have no idea when they were occurring.
So I'll call Mr. Angeli, who never had any conversation after the report. Nonetheless, would it be fair to say that Mr. Angeli, throughout this process, he was championing the provision of additional mental health support to the students?
What?
And in response, the board chose not to renew his contract, is that correct?
Not in response to that. There were many reasons that he didn't get his contract renewed, and it was not because of this.
Attorney Feinstein made a passing reference to a interview you did on Children Health Defense podcast. You recall that?
I do recall.
And you recall, just for clarification, you recall Attorney Feinstein's question, but you also recall the actual interview. Recall indicating that board investigated and learned that Mr. Angeli sat on the board of Northeast Dakota Childhood Council.
Yes.
Member of the Generations.
Yes.
What did that mean?
I believe that is one of the reasons that Generations was the only option brought to us. Was he was sitting with them on the board for the Northeast Dakota Childhood Council. I believe that maybe that's why it was the only option that was presented to us.
Did you think there was something inappropriate about that?
Yes, we should, you hire any organization anywhere in the world, and you're gonna look at more than one organization. You're not just going to take one option. You're gonna have 2, 3, or even decide what's best.
I think that's fair. But I guess what my question was is that, do you think Mr. Angeli was working in some sort of underhanded manner or something like that by bringing only Generations?
I hate to call it underhanding. I like Mr. Angeli, he's a nice man. But I think that there may have been a reason where that Generation was the only one brought to us, because they sat on that board together.
You know, I asked you questions originally, but this is following up on some of Steven's question again about me speaking with staff. You indicated before that Dr. Nash Ditzel stated something in an affidavit. I had every reason to trust it, correct? So if she stated in an affidavit that there are certain conditions at the schools, would it be fair to say there'd be no reason for me to doubt that?
Yes.
So there would really be no reason for me to speak to staff to see whether or not she was accurate. Would that be fair to say?
No, I think you should have gotten a feel for the pulse of our community. And that includes speaking with other staff, not just one person.
Well,
One person's affidavit.
you said before you read the October 24th, 2022 report,
Okay.
and the procedural history, it indicates a speak with additional witnesses, including school staff. Did you forget that?
I did forget that, obviously, wouldn't you speak with?
Read it out.
But I don't.
Well, I'm concerned about retaliation, just like Attorney Feinstein.
Sorry.
Let me,
It's interesting to make an accusation about retaliation. We've never retaliated against anybody. I just appreciate you answering the correct question. I understand.
It's been a long 2 years.
As
Is it, I don't have to worry about it. Well, maybe. Okay, I just want to clarify something for the record. I don't think it's that big of an issue, but I just want to make sure it's clear for the record. You indicated in response to Attorney Feinstein's question, that's the first time you had heard anything about generations at the March 2021 meeting when the board voted generations proposal. Do you recall saying that?
That it was the March meeting. You recall, it was somewhere in that year. I got in December. I was brand new. This all came to me within January, February, March.
Okay. The January 12th, 2022 meeting, safe to assume you were at that meeting.
It is.
Okay. And do you recall the fact that generations proposal actually occurred at the January 2022 meeting? We talk about, you're asked about school psychologist positions. I believe you stated there are currently 2 school psychologists. Do you know the schools in which they're posted?
I don't want to answer without being positive, but I know one is at the high school. And that's so that the other one is at the intermediate school.
Okay. Well, again, as I referenced before, the public school the Killenly Public School website indicates so that October 2nd, 2023 posting was school psychologist vacancy at the high school. So you understand that you're looking for a second school psychologist there, or that the school psychologist who was there has left?
I'm not sure. We'd have to ask staff. That could be an old posting. I really don't know.
You indicated, once again, you reiterated what you had stated before, that your prior counsel advised you not to do anything. That would constitute an admission. Would the board waive its attorney-client privilege so that your former counsel could be called a witness?
So that my former, I can provide the email and speak to them. When you can have the witness, I can give you the email. He sent me an email advising me that he was advised by them.
I'll give you the transfer. Yeah, that would be fun. Thank you. Stated that CHR, difficulty with that for some reason, that they're seeking to add a third day. And so that seemed to indicate that additional support is currently needed. Do you have any idea as to whether that same level of support was necessary during the 2022, 2023 school year?
I don't have any information.
Okay. How about during the 2021, 2022 school year?
I do not know.
Is it your testimony that with respect to the provision of mental health interventions, Killingley was implementing the educational interest of the state during the 2021, 2022 school year?
100%.
How about during the 2022, 2023 school year?
Yeah, absolutely.
Currently, do you believe that Killingley is doing it now?
I believe Karen has worked very hard to go over it.
So essentially, your position is that nothing has changed in the Killingley Public Schools with respect to the provision of mental health interventions between the 2021, 22, and 23, 24 school year.
So I believe that something has changed this year. Post-COVID, we had to add multiple different interventions. So yes, this year has changed. This past year with our new director of mental health services and certain programs that's been implemented. So yes, there is more now than there was then.
So you're saying that actually Killingley is in a better position with respect to addressing student mental health needs now than it was then?
I believe it's in better condition now, yes.
I apologize. Mark, do you recall sending an email on June 10th of 2022 to Angeli and board members saying, part, quote, many people who want children to have mental health assistance are looking to get themselves close.
I don't really get an email, but
It sounds like something you might have written.
I may have. It doesn't typically sound like something I would say.
Is it fair to say that you were skeptical of the individuals who brought the 1014 complaint?
And I was skeptical of them? No, absolutely not. I appreciate their counsel.
Do you believe in parental rights, correct?
I do believe in parental rights and
And that includes the right of parents who brought the 1014 complaint?
absolutely.
Thank you. I have nothing further.
Thank you.
Attorney Feinstein, do you have more questions that we can address before the break?
Yes, and I will limit it to 5 minutes. Again, this is a unfair request. If you can find anything, Winnie or anywhere else, between November 30th, 2022, and my statement of January 11th, 2023, about CHC, I would appreciate you producing it. There is no such document, there's no such statement, and the resent being called a cause of that contract falling through.
It's definitely out there. I'll find it.
Please do.
I'll find all of
There's a statement on January 11th, after CHC failed for them. Now, in terms of retaliation, is it not the case that Kevin Marcoux thought he was retaliated against for speaking out against the board?
I don't think I ever spoke out against the board that I ever remember.
So that during his campaign, a successful campaign election?
It has nothing to do with the simple complaint. This is all about politics. We never retaliated against.
Please don't answer the question. There's an objection.
They're against about politics.
Witness did mention retaliation, so you're allowed to allow it. Might want to state your question again.
Is it not the case that Mr. Marcoux during his campaign talked about being retaliated against by the company?
I don't know what he spoke out there in his campaign. I didn't follow. Absolutely not. This is not about politics.
When I'm talking about politics, I'm talking about retaliation. On the issue of parental consent, it's your position that generations never offered any sort of parent option.
Yes.
I would invite you to look at Exhibit I3. And if you'll start on bottom page 2, a student self-referral. If a student is seeking appointment, staff, school-based health center staff will discuss the involvement of the parent for the appointment. And this B, after initial appointment, or if the family agrees. C, again, requirement that if the student is resistant, they can exit the student into involving the parent. And then after D, there's the recitation of the state law allowed in those limited circumstances where a student can receive counseling without parental consent. And I want you to tell me, I'd like you to review what this language says and tell me what different than CHR has that's different than this.
As I stated again, that I appreciate everything from generations and they're wanting to keep in good with the family unit. That's amazing. But the difference between the two is
that CHR has a piece of paper that will be signed by the parent. That's not the case with generation.
I suggest that you read this document to see the Generations Implementation Plan, which talks about written consent.
Talks about it, it doesn't require it. And there was no form they were willing to provide us with that they would have a parent sign.
You asked them for a form?
We did
Where, when?
very meetings.
A record of those meetings?
I'm still meeting at the record of every meeting.
The issue about only one provider, that ever raised during the March meeting or prior to that? Or 2022 meeting?
Don't recall.
I have nothing for you.
Okay, we will take,
I do have a redirect on the last, for me to review.
and be something that can be taken on.
Attorney DeKeen asked you about his interviewing witnesses. Were some of those witnesses that he interviewed, according to the report, anonymous?
Yes.
And in fact, today he declined to indicate what witnesses he talked to. And but it is still true that he never came down to Killeen to see for himself what was going on.
That's the answer.
Right.
With regards to Attorney Feinstein's question, isn't it true that, again, you, regardless of why you rejected generations, you had the right to take that lawful vote to reject generations? Yes,
Objection asked and answered.
the answer.
What's your response to the objection?
And I said it was already answered. She already answered it anyway. Lastly, in any of these actions that only, again, the allegations were that you only failed or refused to adopt any interventions to address the needs of students. Did you address the needs of students, whether it was by generations or before the vote or after the vote? Did you address the needs of students? You did all the time. Did we ever choose not to respond at all in any meaningful way to the students' needs or the state's needs? And continually deliberately act with indifference to the students? No, we did not.
Thank you. We'll take a 15-minute break. Attorney Stevenson, you can call your next witness. Going to resume the hearing. I just want to, that we are going to have a stop by 4 o'clock. So that you're aware of that. Sorry, Stevenson, you can tell your next one.
You raise your hand. You swear to tell the truth, the whole truth, and nothing but the truth, so help you God. Yes, thank you. Would you state your name, spell it, and your address for the record?
Sure. Susan Nash Stitzel, SUNASHVITZEL, hyphenated in the middle. 81 Crooked Trail Extension, Woodstock, Connecticut, 6281.
Thank you. First of all, could you tell us what your position is as the total staff?
Sure, I am superintendent of schools.
And when did you become superintendent?
August 21st, 2023.
And were you on staff prior to that time?
Yes, I was the assistant superintendent for 2 years.
And when did that begin?
July 20th, 2021.
So were you around when the CIRAC survey was being taken?
Yes,
Okay, and you're familiar with the CIRAC survey?
yes,
And you're familiar with the vote then that took place with the third generation?
yeah.
Now, part of your job is and understanding is to apply for or have some influence on the application process for state curriculum, right?
Yes, in my role of assistant superintendent, I did the writing and then applying.
And did you either write or apply for the grant that had to do with the generations? The buildings?
ESSER 2, which mentions the Community Health Center, did not mention it by name, generations, but mentions school-based health center. I did not submit that grant. That was the previous assistant superintendent. I did submit the ARP ESSER, which again references school-based health center in the narrative. But I did not write that grant. So that grant was due August 15th of 2021. Like I mentioned, I came on July 20th. It was already written. I really submitted it for the grant.
And do you know who wrote both grants?
Yes, so that would have been Paul Breton. He was the previous assistant superintendent.
And do you know how much funding they sought in either of those?
I think ESSER 2 was 1.6 million and our ESSER was, I think, 3.2.
And how do you know, how was, were the, it sounded great.
Did we receive them? Yes.
And what did it do with the money?
A multitude of things, a lot of staffing. And we had some programming put in, camera, school safety was done, such as cameras, grades, bait detectors, flight monitoring for attendance, multitude of staff, professional development for our staff, our teachers, and our paraprofessionals.
And can you describe a little bit more about what it is for staffing?
Sure. Right now we have about close to $1 million of staff paid out of our ESSER. So ESSER 2 is done now, so it's closed. So about $1 million of staff. We have special education teachers. We have SBL specialists, BCBAs, BCABAs. We have a nurse. We have our attendance coordinator. Quite a bit of staffing that comes out of that.
Dr. Nash, did any of those that you just added, that you said were under the $1 million ESSER funding, were they there previously and these all came on because of it?
No, some of them were relatively new, some of them were in SR2 and just rolled up into our cluster.
Before generations, how did killing respond to student living complete?
So, we have always had, a robust, counseling and social worker staff. Our ratio is much lower. Mental health worker to student ratio is much lower than, kind of the state guidelines, if you will. So I think right now we're about 1 to 129 district wide. In terms of mental health worker to student. So we have always had counseling. We've always offered counseling, social work, social workers for our students. We have many tier 1 programs. So we have PBIS, responsive classroom, pyramid for our younger students, ruler for our 2nd through 12th graders. Those are all tier 1, but also have tier 2 components. For years, probably 10+ years, we've applied for the primary mental health grant. That we call the PICTI grant. We have child associates that work with our younger learners, so they associate into school or activate, I should say, into school. I think we've received that for 10+ years now. We have Second Step, which is a SEL program that we offer in our elementary schools. We have designed our schedule so that we have SEL time built into our schedule, and that's pretty common for elementary. However, not as common for intermediate school and middle school and high school. And our high school and middle school have designed their schedule so that there is SEL time built into the day.
Can you tell us what kind of doing? That's now or so.
Okay, ruler, I'm right in the middle. KMS had ruler prior to the generation start. TIS was being trained. High school was trained the following year. But, you know, it's kind of a rolling training where you train staff and you roll it out to students. So couple year, commitment. Like I said, the PICTI program, the primary mental health program, we've had for years. PBIS we've had for years. Second Step years. A lot of this predates me. I know exactly the time. No, I don't, but I know it predates me. Some of the SEL specialists, that's more recent. Those came with the ARPA grants. BCDA, BCADA, those are more recent. Those came with the ARPA grants.
What are the policies?
Did you pull your mic closer to you?
What are the policies that you have in place? Regarding mental health.
Oh, okay. So we have our safe school climate policy, also known as the bullying policy. We have our suicide prevention policy. Those are the 2 that come to mind.
What do you know about suicide prevention policies for governments?
It's been in place for a while. We follow the protocol, exactly how it is written. You know, there are warning signs, and there is actually an appendix that's a list of warning signs that all of our staff are made aware of to be looking for. If they notice any of that in one of their students, they notify administration as well as counseling, and then there's a protocol to kind of go through to make sure, to evaluate the level of risk in a student. You know, if that level of risk rises, and then we have another set of protocols that we follow. Those protocols here. It's in the policy, there's an appendix, and there's a form that follows in the appendix.
Can you, that book for services?
Yes.
And I think it's in the work, or it's already needed.
Okay, that's four.
And what's the 514.5?
Yes.
And you said there were others. You look at exhibit.
Mm-hmm.
And there.
Yep.
Are those the additions or receipts to that policy that we're talking about?
Yeah, so exhibit 5 is not part of the policy. That is would be part of the protocol that our counselors would be using. But exhibit 6 is part of the policy.
You, for the record, what is exhibit 1? How is it used?
Sure. If a student kind of rose to the level of counseling that we really need to assess the risk, then we would be, our counselors or our director of mental health would be using the Columbia scale, widely known scale, to address the risk of a student that maybe has made some suicidal threats.
And then exhibit 6, what is suicide intervention?
Yeah, that's for documentation, right? So that's part of the policy. Part of the policy, and we would go through that to make sure that what we are doing is documented. And that we have a record of what we've discussed with the student and what interventions that we're trying.
And what sort of intervention? Run through what you do said. For instance, if someone's about to commit suicide or it needs treatment.
Well, that seems to have risen to a higher level. So, you know, if there was really an imminent risk there, then we would call 911 or 211, depending on the situation. Yeah, and so, you know, if, for instance, a student, you know, we were concerned, right? You know, maybe it's not an immediate risk, but we're highly concerned. Then we would want more in-depth evaluation, and we may have to reach out to another outside of our school agency that would be doing a higher level of evaluation.
And you know that these policies have been implemented and
Yes.
so we have identified students who are in need of this kind of help.
Yes.
Would that be before the moment generation or the survey, survey?
Before and after, yes.
And so, what do you describe how and why the staff would be aware of any student in need?
How would staff be aware? As educators, we know what to look for. We have had trainers come into the high school to provide us staff with education around specific things as to what to look for. Later this year, we will be having the GPR program, the suicide prevention program, where again, we'll be training staff. We don't do it every year, but we do it every several years to make sure that our staff are up to date. It's also, you know, within the policy. I don't see it in this particular exhibit, but in the policy book, if you look, there's another page after that actually has a list of things to look for in terms of students that might be at risk and students that might be at elevated risk.
So that would be in that before generation.
Right. Yeah.
For how long do you think?
I believe this is a 2004 policy. Yeah, so a long time.
And has that policy also been in effect after the moment generation?
Yes.
So this is kind of a routine daily policy that the staff and administration are aware of.
Yes.
Have you heard of any students who were in need of mental health treatment or intervention that have not been able to provide it for them? And that is before the moment intervention and after. Right. So we've heard testimony recommendations. Yeah, there were so many people after the pandemic, so many students really overwhelmingly they have to be triaged and situations. Were you aware of that and you have hundreds under your assistant or supervisor?
I knew about that when I had to collect the information for my affidavit. That's why when I learned that, was I directly involved in that. As the assistant superintendent, I oversaw curriculum instruction and grants, so I not necessarily get involved in counseling, social work, and that kind of thing, but I was aware. Yes.
Okay, so can you tell us about your affidavit and the 600 students or whatever you were describing?
Yeah, so in speaking with the then director of counseling, I asked about the responsive counseling, and there's a way that we code that in Power School. When students come down to visit counseling, there's different codes as to why they're there. Responsive counseling is one of the codes. So we were able to pull that and to find out how many students had been seen for responsive counseling.
And was there any indication that these 600 students did not get help themselves?
No.